छुआर पुणी सेशन स्टार्ट हम आउ सार जो अश्विनी सार जो नहीं आम दिज को बुझेबारे सी 15 दिन भितर आई कॉल्ड हिम 1000 टाइम्स आई ट्राइड आल्सो
आपण मिस्टर अश्विनी दास को कोन से मेंशन करी
आज्ञा
अश्विनी दास मैडम सार को कोन से मेंशन करी
सर यस्टरडे ही एक्चुअली मेट मी से मते मो घर को आसिले से ए भीतर तीन थर श्रीतम संगे बसचंदी इंडिविजुअली आम दी जन संगे बसिबे कहितले बसिलेनी
लेट मी हियर हिम बिकॉज़ आई हैव अपॉइंटेड हिम एज amicus curiae on your behalf so let him come and say tomorrow 2 o'clock you come tell him to mention I want to know but he has said something he being a senior person he want to mediate between both of you I want to hear from him instead of you
yesterday he left my case and yesterday he insisted me to take 5 crores as permanent alimony and leaves Ritam.
It's all right tell Mr. Das to mention I'll just tell Mr. Das to
it's a FAO.
First there is a senior give the memo I'll just check it up wait when the seniors are there you respect them okay yes sir okay please give we'll see because of 2-3 days I didn't hold the court therefore there must be some every criminal appeal has the same story what to do I'll include that in the weekly list at least include that are you ready with the matter get ready with the written submission and all so that whenever I get time I'll pick it up okay
I beg pardon, my lord.
bail jump
Bail
tied there is no tied up now because of that judgment up to the
I beg pardon, my lord, to make a mention, my lord. My lord, same cause of action. Several complaint petitions were filed. In 4 cases, your lordships have been pleased to stay all the proceedings and directed there. Again, another complaint petition has come to my notice, which has been filed subsequently with the same allegation, my lord. Your lordship has already admitted several cases, and those interim arrangements are already made.
We'll see. But you are supposed to be somewhere else. Why are you coming?
No, tomorrow, my lord, is my last date of
yes.
And the one Belgium matter is
put it tomorrow. Yes.
Se case ta kalli ki be asu.
No, we'll see that.
Seta asile se same order khali habo.
We'll just check it up. Huh? The connected matter numbers you have given.
Connected matters number sethere sabu achi mu dei douchi ta.
You give it so that yes.
Workman compensation matter. Specifically, takes to 25 right.
Take it up. Well, streamline within 2-3 days. Things will be all right.
3 matters.
Now he is restless. He is restless. You tell me.
It's a 2011 matter. I am for the respondent. Pleadings are completed.
What is that? Appeal?
FAO.
FAO.
Actually, the things is petitioner tried to constructing house before the disputed land. That's why it's very urgent. Actually, घरो ता ऊपर कॉस्टल है इंदिरा आवास केमती ना डिस्प्यूटेड लैंड अछि
Could see.
To leave the January matter, but not listed matter.
Give all memos. Better that we will.
Tomorrow, my lord.
Not tomorrow. We'll see. I have to adjust the list. We'll see. Within this week we will adjust everything.
This is a modification.
Maybe. It's all right, but it's all right. Stay up can be not tomorrow, not possible.
During that, as for the direction of this,
You know, convictions are not to be stayed like this.
This is a modification.
Yes.
Modification in respect of the Miller offense inherently wrongly typed instead of FOCSO, it is NI Act will type.
This matter? Okay. Yes.
Well, my
Please
My case, my lord, 2024 CRLMC, my lord, will also directed me to file an adjournment petition so that court below give time, my lord. Now, 2025, my lord, court below trial court saying that adjournment petition clarify it. Hon'Ble High Court not clarify it will continue 6 months, 2 months. Now, we clarify it, otherwise time will not give you. Adjournment.
What is this matter? Means
CRLMC, my lord, passing of Cognizance file, my lord. Your lordship can file.
you want the dismissal of that. There must be, there is nothing on merit, maybe. That's the reason stay was not granted.
That is the.
Okay, you give it, we'll see.
Okay.
Please,
So, clarification on try important clarification.
Yes, yes.
20 January 20.
Give. Yes, madam.
Your Lordship, this is pertaining to trademark and copyright, and without jurisdiction, they have sealed my factory. And since 10 days, my factories has already been sealed, Your Lordship. On 20
What have you filed for quashing?
for quashing, Your Lordship. Without jurisdiction, they have sealed it, Your Lordship. And notice was issued on 25th, Your Lordship. And it is posted to 12th. Already 10 days has been sealed. And if it is not, it's on 12th, it will be too long, Your Lordship.
Then put it on 10th.
Tomorrow, Your Lordship.
10th.
Your
10th.
Lordship, tomorrow.
10th. Tomorrow, see, once I list like this, then the
So maybe
entire
on-
matter gets stuck, you know.
Maybe on 5th, Your Lordship. because
Let it be on 10th. Let it be on 10th. Yes.
My pardon, your lordship. My lord, simultaneously
Obliged,
two
Your Lord.
proceedings has been, my lord, processing, my lord, initiating by the FIR. First FIR has been registered. Thereafter, complaint case has been filed, and the Law and Court will has taken cognizance in the complaint case on
Only
same
Cognizance
subject
has been
matter.
taken, nothing great has happened.
On same
Wait,
subject.
give the memo. Nothing great.
Yes.
In every case, there is something or the other.
Pardon to make a mention, my lord. 482 application, case matters, my lord. Matter has been compromised with the parties on the basis of.
What are the offenses?
420, your lord. Both the matters, my lord.
देखी लोग तो
Belgium matter, man.
Belgium दे.
Pardon, Your Lordship, criminal appeal, Your Lordship, against conviction in vigilance case, Your Lordship. The matter is ready for hearing and it was in the weekly list for several months, Your Lordship. It may be taken up in the weekly list, Your Lordship.
Weekly list, I don't know whether I can touch it or not. We
Which-
waste half an hour you waste in mentioning, then that
With-
affects your
With the lordship's
perspective
permission,
of hearing.
I'm constrained to mention before your lordship. Your lordship will remember, in my absence, the opposite party took the time. After lunch, postmaster is.
I don't remember.
Hey, my lord. Your lordship may.
I don't want to remember also.
Opposite party, without intimating me, took the time.
What to do? Your brother have done it. What?
Right. I have mentioned for continuance of entry order, and your lordship directed to continue the entry order, and so also list this matter. Your lordship may can see.
I don't know.
The order sheet am dଉଛି mo ଲେଖା ହେଇଛି ମୋର non appearance
Huh?
ସେ କୋର୍ଟ ମାଷ୍ଟର ଜାଣିଛ ସେଟା କିଛି ହେଲାନି ମୋର ସେମାନେ ପର୍ସୁ କଲେଣି ତଳ କୋର୍ଟରେ ଜାଗା ତାଙ୍କର ଏଣ୍ଟ୍ରି ମର୍ଡର ନାହିଁ ତାଙ୍କୁ ଭ୍ୟାକେଟ୍ କଲେ
Was there an entry order?
yes my lord I have mentioned on the relevant court after launch while the 64 item was taken up my 63 item has been adjourned.
No, where is the entry order?
Entry order is not there not
No, the earlier entry order.
entry order is there entry order is there
Entry order there. এটা লোকে continue করো কালি লগে দিও
again oblige your lord.
If the entry order is there, then
entry
you
order
can-
is there because a doctor and advocate fighting the your lord.
Okay.
I am appearing on behalf of the
Yes.
Your Honor, I called him now for 2-3 times. He's not picking my call. Let the court
Wait,
call him.
madam, have patience. Things are not done like this. Wait till 2 o'clock, wait. Yes. For a purpose, I am trying to do it. For your good only. Wait, don't. Yeah. Yes. Any mentioning online? No.
My lord, my lord,
Yes.
my lord,
Yes.
item 58, 90, item
Lord,
58,
Any mentioning?
kind permission, Lord,
item
Lord, the
58,
matter.
my senior is out of station.
Yes, Mr. Mishra. He's not.
Lord,
Item-
with kind permission, my senior is other side, Mr. N.C. Panigrahi, item number 8. It is matter, my lord, it is no stage there, no interim order. I have to file a reply to my senior's counter.
Okay.
Item
Okay,
8,
adjourn.
my lord,
On the
4 is
request.
time, I pray.
Yes, Mr. Panigrahi. Do you have any objection to that?
No objection.
Obliged.
Adjourn on request. Huh? Yes.
My lord, item 58, my lord.
Yes.
I'm a item 58.
Okay. We'll see. 1 minute. 1 minute. Yes.
Any mention of item 6? Item 7 to 19?
My lord, item number 16.
16.
Yes, my lord.
Yes.
I pray for 1 week after, my lord.
Adjourn on request.
May I please, my lord, item number 10.
10.
I am appearing for an information and a compromise is there. Today they are unable to appear before this one.
What are the offenses?
Offense 376. But initially the main accused has been acquitted and compromise. They are co-accused persons,
Okay.
not principal accused.
Okay. When do you want?
Next month, that's second.
Correct.
Again,
Okay.
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 Item 10.
Yes. Yes.
10.
10. Yes.
Thank you.
Item 20 to 34. 35 to 50. 51 to 61.
My lord, 50 item, 58 madam.
He is 58. Na? Yes. Yes.
My senior is out of station, my lord. I am.
Just check it up. Your apparatus is not properly functioning, it seems. Voice,
Yes, my lord.
we can't hear you.
My lord, 58 item, my lord.
Yes.
Yeah, I may want to adjourn, my lord. My out of station.
You want an adjournment?
Yeah, my lord.
Okay, adjourn. AGTG can't hear. Yes. Yes.
62 to 68.
My lord, item number 65. Permitted to withdraw. I have already filed a memo.
65 withdraw.
Your Lordship, for item 67, Your Lordship.
67, yes.
Yes, Your Lordship. On behalf of Mr. Basan Kumar Das, is unable to appear today, Your Lordship.
Okay.
I seek an adjournment for the same. And also, Your Lordship, there was an interim order that the adjournment petition will be
Is there
allowed.
any interim order already?
There was an interim order that the adjournment petition will be allowed. Your
Okay.
Lordship.
Same interim order to continue. Yes.
Much obliged.
Yes.
69 to 78.
Your Lordship, item number 72, it's a compromise matter, Your Lordship. The parties are present, Your Lordship.
74.
72, Your Lordship.
72.
The parties are present.
What are
Lordship.
the offenses?
363, Your Lordship. So, Your Lordship has asked them to come. They have come, Your Lordship.
12 o'clock?
They have come.
Yes.
Your Lordship may kindly fix a time, Your Lordship.
12 o'clock?
12
2 o'clock? When do you want? 2 o'clock?
2 o'clock.
2 o'clock. Okay. Yes.
Obliged.
Yes.
79 to 83. 84 to 92. 93 to 97. 98 to 104.
104 million out of conviction 10 years, near about 5 years inside the jail court for the accusation of 37 kg, carrying of 37 kg of gold.
Are you on bail?
Na bail motte nahi 5 वर्ष la rolling.
To move a bail application.
हम bail move करते
Okay, I'll hear it. Bail. 5 years you've already undergone.
near about 5 years.
Near about or
No, 5 years.
with remission or without remission? Without remission, how much?
Without remission. Near
Without
about more than 4
then
years.
maybe more than 4
years.
Then it's about 10 years, 5 years. Okay. Weekly, but bail he bail only.
More written note दिया part hearing में इतला देखते हैं कि bail हेले भी हजू रही जान. अब किसी criminal antecedent भी नहीं.
Just see 436 capital A if you are covered by that.
Conviction में.
Just check it up.
Yes, yes.
You may get some judgment on that. You may get some judgment. Yes. I'll take it up. Okay.
Today.
Yes.
Item 1.
What do you see? Do you mention? Not filed. Item 1.
My lord.
What is this? The judgment was reserved long back.
Yes, my lord.
You filed. You are supposed to file written
No,
submission.
I have filed written notes. That's on record, my lord. On the very same day.
While dictating, I saw that there is no written note and all. I have to recall
No,
everything.
I had filed the written note.
Okay, I'll
It was mine.
just
If
give
your
it,
lordship
yeah?
wants, I'll file one more copy.
No, it's all right. You have filed it, na?
Yes,
Is
my
there
lord,
a,
on the very same day.
have you got it? Yes.
Yeah, I have also given the written note.
Written note. Okay.
Let him
Both
copy the
written notes
copy
are there. The parties have filed the written note of submission, which is taken on records. It will be given. Okay. Next.
Item 2.
Item 2, Your Lordship. I'm on VC, Your Lordship.
Okay. Parties are directed to file written note of submission. They haven't filed the written note of submission as yet. 2 more weeks time is granted to
Your Lordship.
parties. If written note of submission is not filed, within the time granted, the matter will be listed before the hearing. Okay.
Your Lordship,
Yes.
Your Lordship, item 2, 1 minute. Your Lordship, item 2, I want to file an affidavit, Your Lordships.
Yes. I gave 2 weeks, you within 2 weeks file, huh?
Your Lordship may directed to file an affidavit.
You file affidavit also.
Yes.
Written note of affidavit. Yes.
Yes, Your Lordship.
Yes.
Item 3.
In this case, I'm appearing for some of the accused persons matter, opposite parties.
Yes. Here, the written note of submission has not
I'll
been.
file by tomorrow.
Same order. Huh? Okay. Yes.
Item 4.
Item 3.
See, what happens is again I have to read everything. You know.
Item 3.
Submission.
That order I have given. You file it within 2 weeks. Huh? You file it in the counter. अच्छा ठीक okay. जो तो फाइल है ना तो टू सेम ऑर्डर कर दो जो फाइल है ये करो ठीक okay.
Item 4.
Item 4, my lords, that these matters may be taken off under the to be mentioned on Friday, my lords.
Sure.
Because this involves a trickless question of law. One day.
It's all right. I am giving 2 weeks time and you file it.
No, let it come on Friday, not to be mentioned.
I don't know whether.
Second case is called lordship may resolve.
No, if the petitioner will not be willing to file written note of submission, the courts will be different. So therefore, I am passing a common order like. Let us see. Yeah? Okay. Next 5.
Item 5. Let's say we had filed written note of submission.
When? Are you going to file?
No. File.
When? Today?
No. That day.
When have you filed? Okay. It's all right. 2 weeks.
This is that case where FRT has been filed.
Okay. It's all right. 2 weeks. Yes. 6.
Item 6.
Petitioner, the discharge application having been rejected, I have approached your lordship. Now, to cut short the situation, they have filed a written note on the last occasion. May I just draw your lordship's attention to that written note of the prosecution?
What is this matter is about?
My lord, yes, I am added as an abator. I'm the abator. I'm son. In 2010, I joined government service. For the prior period, after I completion of my engineering degree, I am doing some business. For that period, between that check period is 1971 to 2012. But for me, it is from 2003 to 2004 to 2010. For that period, I have been added as an abator. Total disproportionate asset has been found to be 38% in a family of 6 persons which are admittedly government servant, are serving, and the check period of lordship, remember, is more than 30 years. Now, what is their case? After I passed out my engineering degree, I borrowed some fund from my father, started doing some business, bought a JCB, excavator machines and other machines. I am mechanical engineer, hired them and earned some money, and also paid my income tax. These are all record.
But your source of business is
from my father. From my father. That's I'm not also disputing. It's initially fund has to be borrowed from my father, and I have taken borrowed is not the correct word. He has given. So under these circumstances, the question first is whether I can be an abator. Just for a moment, if your lordship leave it that, I will demonstrate there is no DA from their written note. Why you am saying, my lord? Your lordship kindly have that.
DA vis-a-vis your father.
Even that is not there.
You are not arguing for your father.
No, my father is dead. That's another thing. Prior to charge. Prior to framing of charge, the main accused has died. Now, whether the proceeding will be continued under section 109 or not, that's another issue. I'm just saying on the fact. I have taken loan, loan of 14 lakhs to procure a machine, excavator machine of 17 lakhs 50,000. Now 14 lakhs shown in my income side, 17 lakh 50,000 shown in my asset side. I made repayment, as against 14 lakhs, I made repayment of the entire loan at 17 lakh 60,000. That is also shown in the expenditure.
Yes.
So my case is simple. My lord, these 3,60,000 or 10,000 which I have paid as an interest can be added as my expenditure. And that's what the Honorable Apex Court says. A and B, in my income tax return, my gross income is suppose 6 lakhs.
Have you prepared a written note?
I have prepared a written note. I'll file a written note in next week.
I will release it next week. I'll just both the things I'll compare.
I have given the detail.
Yes, I've seen it. So therefore, you have given an exhaustive written note.
Each case is my learned brother's case is that if the loan is taken in the income side, asset is
Okay, what is the charge? DA?
DA. E109.
1 minute. DA. If the main accused goes, who will explain the disproportionality? He can't. Only the abettor has to explain his part of the
part of income.
His part of that you concentrate there.
Tanko part of income, whatever source and whatever expansion he is giving, whatever income tax they have paid, that has everything
And
has
the
been
law
taken
is-
care of. And
Then you have filed a very detailed.
Even law is
thing.
now
And para 5 page 5 is the chart also you have given. And just check it up and
Yes, my
revert
lord.
it.
Now, another aspect is that, my lord, now I am not a married and public servant, so I cannot be tried by this special court.
I understand. Therefore, that is the reason I am.
Then it will go to the other IPC.
No, to that extent, I have given the judgment.
No, that also. Obliged.
Yes.
Item 7.
Yes.
May I please, Lordship? I am appearing from BC Barampur, Ganjam.
Yes.
Lordship, the petition challenging the order of Cognizance passed by the Honorable Raigada Court in GR case
Yes.
number 9 with 2012. My lord, ये वाइफ खाली मतलब हैरान करने पे केसटा पकीज my lord. बाहागर हमर तिनी
That can't be a ground, sir. So,
Vigilance.
ହଇରାଣ କରିବା ପାଇଁ ଫାଇଲ ଫେଲ କଲେ କ'ଣ ହବ?
Lordship, ବାହାଘର ତାପରେ ସିଏ ତା ମାଗରେ ରହୁଥିଲା.
How the cognizance order is wrong, you tell just.
No lordship. ସିଏ ବାହାଘର ହେଲା ପରେ ସେ ତା ମା ଘରେ ହିଁ ରହୁଥିଲା. ମୁଁ ତାକୁ
I'll
ପଇସା
issue notice
ପଠଉଥିଲି.
in matrimonial dispute. Issue notice in something. Yes, issue notice. Written notice. Yes, next.
Item 9.
My lord, I am on VC.
Yes.
Appearing on behalf of Mr. Panda, I seek for an adjournment. Next week, my lord.
Okay. On behalf of Mr. Panda, the petitioner, a prayer needs for adjournment. Yes.
Item 11.
I put day after tomorrow.
Now you can't decide the date. Either you argue or she can adjournment.
Yeah.
Date will be decided by the court. This is very wrong way of take the matter on that day that this court has to decide or you will decide. Then you only request that please adjourn or something of that sort. But don't decide a date and tell us. Then you write a judgment and give, I'll sign it. Again you tell what do you want.
Say I seek.
No, properly you tell what do you want.
I prefer an adjournment.
Simply adjourn. Okay, simply. But whenever you appear in the court and when you are telling, just polish your language. Don't fix a date yourself and tell that take the matter on that day. Never even say that. Okay. Okay. On the request of legal counsel. Adjourn. Yes.
Item 12.
May I please announce? The petitioners here have challenged the criminal revision order passed by the additional district sessions judge Baripada.
Use mic, sir.
Additional district and sessions judge Baripada passed in a criminal revision. And
Yes.
the petition has been filed under 482. In this present criminal revision,
Yes.
the petitioner has never appeared. The judgment clearly says none appears for the petitioner. But however, without going through the documentary and the oral evidences adduced before the subdivisional magistrate, twice subdivisional magistrate has allowed that the petitioners are in possession of the land. And
You
in
are the
revi-
second party before the
Before we are the second party before the original subdivisional magistrate.
In the revision petition.
In revision petition, we are also the second party.
Second party. Now,
Yes.
now you please come to page 40, para 3.
It's 40.
Read it.
Yes.
After getting notice, the second party member appeared and filed the written statement. According to them, you have filed the written statement.
We have filed our written statement. The petitioner has never appeared in the revision.
But you contested.
I contested. The petitioner has never appeared. But the categorical finding of the subdivisional magistrate is that we are in possession of the suit land. Twice the subdivisional magistrate has decided. And in this case, without going to the conclusion that the partition land has never been partitioned between the parties, and this is a joint land, and ROR also speaks that without going to the facts and narrated before the subdivisional magistrate, the additional district sessions judge has categorically come to the finding that we are not in possession, the petitioner is in possession. That I have challenged in 482.
Regarding possession.
Regarding possession, and that finding is wrong. That is my categorical.
I'll issue notice.
Yes.
Issue notice to.
They stay.
No, what is the order? Effective order is nothing.
Effective, yes. Let notice go.
Effective order. You are not in possession. That is the finding. If I stay, will you go and sit in the position?
The categorical finding is that they are in position.
The finding may be wrong,
yes,
but I can't dispose.
Yes.
Let us see. I'll issue notice and yes, yeah. File the process. Here.
Item 13.
Item 13, may I please, Your Lordship? Your Lordship, in this matter, in the same FIR, 2 cases have already been heard by Your Lordship, and it has been fixed to on 23/2025. This matter may be also taken on that date.
23/2025.
CLMC number 4078 and 3936.
I have instruction to appear in this matter on behalf of the informal matter.
Come to the front. Yes. What do you want?
Well, I have instruction to appear in this matter on behalf of the informal matter.
So and so entered appearance on behalf of informant opposite party. Or party, yeah. Under takes to file.
On behalf of Mr. Chaudhary, AK Chaudhary.
Under takes to file. The counsel for the petitioner submits that the connected matter TRLMC 4078/2024 is listed for hearing on 20th March. 20th March. Yes.
14.
14. Okay. 402 withdraw. Yes.
15. May I please?
Yes.
My lord, offense under section 498A, my lord. My like me to my lord compromise this case, my lord.
I issue notice.
My lord.
Bring them. Issue notice. Yes.
Oblige, my lord.
17.
Challenge the cognizance under section 447, 227, 379, 34 of IPC, my lord. At that time, I am the junior engineer, and the direction of the government, I am doing my work, and my FIR has been lodged against me by the 1CC case, my lord.
Yes.
1CC case now 4 of 23 in JMFC Soda Ganjam, my lord.
Yes.
Sir, actually, my lord, I am the JE, my lord. I am working on the direction of the government.
Chiranjeevi Sahu.
Yes, my lord.
Okay. You are challenging cognizance order.
Cognizance order, my lord. 447, 341, 427, 379, and 34 of IPC. I am Ananda Surya Pradhan and Tahsildar.
Chiranjeevi Sahu, let us see against Chiranjeevi Sahu, what are the allegations? Let us come to Chiranjeevi Sahu.
16.
Chiranjeevi Sahu directed them to continue the work. That is the allegation.
What are the allegations? Yes.
Just 8 lines below top.
Why don't you file typed copy of the complaint? I don't know.
No.
Father of the complainant, Satyavadi party, being the only son. who is parent.
Case arising of the protected person or
Owner of that property up to their death. Position.
I'm working under the Tahsildar, my lord.
Of course, some so you have land to component to not Where is the allegation against Chiranjeevi?
No, madam.
Where is the allegation against?
Here is a case arising of protected person also.
I understand where is the allegation. I am reading protest petition.
That can the name of the present petitioner also, but he has clearly
Surya
he has clearly stated that is JE, your actual engineer PWD. Present petitioner is the JE also.
The accused Surya Pradhan told the Tahsildar so-and-so, assistant PW engineer so-and-so, J. Chiranjeev Sahu directed them to continue the work. He directed them to continue work. Nobody knows what. I issue notice. Issue notice. Only cognizance is now taken.
Yes, ma'am.
Cognizance is taken, and the allegations are also very very minor. Yes, issue notice written so. In the meantime, petitioner is granted liberty to move application for the trial court, seeking an adjournment, owing to the fact that the matter is sub judice before the court. Yes. File the process immediately. Madam. Yes, I have also passed the order. Yes.
18.
File the process, madam.
Yes,
This will course. Yes.
Wait, please, your lordship.
Yes, sir.
In the present case, my lord, the application of an application under 319 CRPC has been allowed, and these present petitioners were impleaded as accused persons after examination of 7 witnesses out of 9
319.
319, my lord. On the last occasion, my lord, your lordship had asked me to.
After the witnesses are examined, then only 319 without examining.
My lord, after the 7 witnesses,
Then the evidence might have come.
My lord.
Let us concentrate there.
My lord.
Let us see what are the evidences which, according to the prosecution.
My lord, that is at page number 29, annex of 4 series starts the depositions, my lord.
What is your name? Name is Abhijit
Bastia and Jagatjit Bastia.
Let us see.
The basing on the depositions of PW 1, 2, 3, and 4, my lord, I was impleaded as an accused, my lord.
Yes.
On the last occasion, your lordship had asked me to collect his judgment because in this case, my name was there in the FIR. However, bearing these 1, 2, 3, 4, none of these witnesses said anything against me. So against me, charge sheet was not filed against me. In the deposition also, only these 4 witnesses are.
But your name was there in the FIR.
In the FIR, these 4 persons have.
Name was there in the FIR. Charge sheet you have been exonerated.
My lord.
And thereafter the same witnesses, 3 of the witnesses deposed against you. Therefore 319.
My lord. My lord.
This is the story.
My lord.
And how will you deal with these 3 witnesses?
My lord, these 3, there are contradictions in the statements of this.
That I will not go into.
My lord, allow me, my lord. On the last occasion, I had made the similar submission. Your lordship had asked me to collect a judgment where the name of the petitioners have been there in the FIR in the 161 and basing on the independent witnesses. How can they this 319 application be quashed, my lord?
I don't remember. Have you got any judgment?
I have collected a judgment, my lord.
But how will you, these 3 witnesses, those who have deposed against you?
My lord.
Can you take those evidence out from the record?
Well, the evidences, their depositions also, there are contradictions in their depositions.
The contradiction at 319 states, can the court at 482
my lord,
go into the contradiction and say that no, it's not required?
Well, the degree of satisfaction at 319 is not similar to that is entered at the time of.
That's right. There are 3 witnesses, those are very specifically.
No, my lord, not very specifically, my lord. They have said all accused persons. They have made specific allegations against the accused person who has been charge sheeted. And regarding
the name was already there in the FIR. That's the problem. My lord, I don't know how you have managed in the investigation stage. I don't know.
Despite that fact,
Going to the merits of the case, your lordship, the accused order of rejection 319, whether CLMC is maintainable or not, that is your one of the question of the.
Forget about the
Yes, that's
technicality.
right.
If there is,
In the
and if you say 482 is not maintainable,
maintainable,
he'll file something else. It will come to
Yes,
this court only.
and that part,
Unless
your
you
lordship,
think-
and the present petition is very.
Come to the merits.
Yes.
Don't get into
Yes,
it.
yes,
No.
lordship.
This is a case where
It is, we waste most of our time whether it should be filed, this should be filed, that should be filed. Come to the merits.
Yes, yes, sir.
And finish it up.
my lord, this was a case where the allegations were under section 302, my lord. The allegation, in the allegation, the complainant had specifically named the respondent number 2 therein. My lord,
have you given this judgment to him? I'm just passing it over, give it to him so that we will not waste time. Pass it over. Just check
I'll
it
give a
up.
judgment, my lord.
Whether this judgment helps him, then
Yes, sir.
yes.
At 2 p.m., my lord.
Pass over 2 o'clock.
My lord.
Yes. Give the judgment so that we can
I'll
read
give
it.
a judgment.
Yes.
19.
Yes.
Petitioner is the informant. He has
Yes.
filed a FIR under annexure 1 against the 5 accused persons. And the medical report also I have annexed, which clearly shows that the offences are established against the accused persons, but subsequently police has submitted charge sheet against only 2 accused persons. So far the remaining accused persons is concerned, police has not submitted charge sheet, for which I have filed a protest petition, and that they are also involved. But the learned magistrate says that since police has already submitted charge sheet on the basis of cognizance has already been taken, I will not entertain the application.
Let
They
us
have
see.
rejected.
Very good.
That is annexure 5, page 39.
5. Yes. Read it.
Well, Lordship, can I have a glance to page 40?
You are the informant, huh?
I am the informant. On further perusal, it reveals that the cause of action arose on so and so date at about 7:30 p.m. and a complaint regarding the same occurrence has been filed, and the same is registered by PS case number so and so, which is pending now GR case number so and so in this court. On verification of GR record on perusal, it is found that the police has submitted CS against 2 accused persons, namely Podaravinda Mishra and Prabhupada Mishra under section so and so, and Cognizance under so and so has already been taken against the accused person, namely so and so. It is also found that the case record is posted on 20/2024 for the appearance of the accused persons. This court cannot entertain a protest petition after taking cognizance of an offence and police report arising out of this same occurrence. It was held in so and so case. He has relied this.
The cognizance has been already taken against the same accused person.
No. So far, other accused persons, I have filed this protest petition. So far, other accused persons.
Show me the here the accused persons are.
Lordship, kindly have a glance to the accused persons, page 12. Pradharvendra Mishra, wife of Pradharvendra Mishra.
There are
Prabhupada Mishra, wife of
4 accused persons.
5 accused persons. 5 accused persons.
No. Come to page 39. Page 39. Just see 4 accused persons. Name are there. Isn't it? Cognizance is taken against these 4 people. Isn't it?
Only against 2 persons.
Where is that?
Your Lordship, kindly see cognizance.
Yes. Cognizance order, where is cognizance order?
Cognizance order I have not annexed, but in page 40 it has been clearly reflected. 2 accused persons, namely Pradharvendra Mishra and Prabhupada Mishra.
Where is that?
That one, two.
It's already been taken.
Yes, ma'am.
Against accused persons, so.
Line number 8. And so far, other 3 accused persons, police has submitted.
Other 2 accused persons.
3টা এটি ভুল লিখে দিয়েছেন কোর্ট অর্ডার তারপর প্রোটেস্ট পিটিশন লর্ডশিপ কাইন্ডলি সি 5 accused persons, page 33 and 34.
What are the allegations against these people?
Allegations, my lord, 354 as well as other allegations 147, 148, 294, 323, 354, 354B, 427, 506, 149. They have entered into the house.
Only
and
Pradharvendra and Prabhupada Mishra have charge sheet filed out of 5 accused persons. But the protest petition is filed against including present 2 and other 3 persons, those who have not been charge sheeted. Therefore, the London Trial Court is maintained that already you have to take cognizance against the Prabhupada Mishra and your Lordship Pradharvendra Mishra.
But see, the FIR, it's all right, but in the FIR, all the names were there.
All the names are
Then, yes, issue notice. And there can't be a stay because at least let it be proceeded against two accused person. Why to stay? Huh?
No stay. I'm not
It's no.
paying for them only. It's notice.
Yes. Then the trial court is absolutely wrong. Shall I set aside
Let it be.
and send it back?
Raising of the protected person, let me notice issue to OP private position.
Opposite party.
So that it can be.
It has to be set aside.
Yes.
Yes.
Item 20.
There is a case arising out of complaint case for quashing of court of cognizance on the grounds of settlement.
What are the offences?
But here is the case, do not do inquiry report is not there, but offense is also.
What are the offences?
406 and 420 are also.
Complaint case, huh?
Yes, sir.
Settlement.
Yes, so that is in stated in paragraph recorded in the grounds.
Okay, I'll pass over.
Yes, sir.
The parties may come out. We don't. Yes.
21.
Yes. 21. 21. Pass over. Pass over. Yes. 22.
22.
22. Yes.
When it's a petition under section 482 against the 1cc case, cognizance taken in the taken by the SDM court Kotak. My lord, the allegation in the 1cc case are under section 499, 500, 501 and 34 of IPC. My lord, actually these cases are not made out against the present petitioner. The present petitioner is alleged. My lord, she is alleged for defamation and
What have you done?
My lord,
What have you done?
my lord, we have appeared there and but I have no allegation is made out against me. My
Let's see what are the allegations against you.
My lord, the allegation, sir. One affidavit is swear by this petitioner against the on the instigation of the one Vijayalakshmi Das that the accused the present complainant has taken money to give him.
You have given the affidavit.
My lord, actually that affidavit is now sworn by me, but my signature.
Come to page 16.
My lord, place 32 is the affidavit. My lord.
Page 16, specific allegation.
My lord.
The contents of the affidavit owned by accused number 2, 3 and 4. You are accused number? Jesse, you are accused number?
3, my lord.
Yes. You are accused number 3. Yes.
My lord. My lord, there's just 2 passovers may be given, my lord. 2 passovers may be given.
But you are doing very well. You tell you, why are you? I have read it just now.
My lord, the contents of the affidavit shown by the accused number 2, 3 and 4 are alleged to be for defamatory statements to the complainant, and such declaration in the affidavit has damaged the reputation of the complainant in the society. The accused number 1, in order to defame the complainant, used such affidavit in different proceedings against the complainant, which tarnished the personality and prestige of the complainant. When the matter came to the knowledge of the complainant, he became mentally shocked and was not also to.
In page 14, para C.
Minute.
Specific allegations. Para D, specific allegation.
Minute.
Para E, specific allegation. How to get out?
My lord, actually, this affidavit is not sure, was not within my knowledge, my lord.
Where is that affidavit? Show me the affidavit.
My lord, page 32, my lord.
32.
My lord.
Let us see. 32. Come to that affidavit. Yes. This is the offending affidavit.
My lord.
Okay.
This affidavit, in this affidavit, The contents is that I am the deponent in this affidavit and permanent resident of the above address, that I have paid rupees 5 lakhs to Suryamani Tripathi, son of Nilakantha Tripathi.
Your affidavit is there, Niharika Pandai.
My lord, my
26/9/2022.
my
You have
signature,
given the affidavit.
my signature is there.
That I
but
know,
but
your signature is there. How can I help you? Tell me.
I have not swear this affidavit because it is a.
How do you know you prove it?
My lord, the actually it is a the complainant and one Vijay Lakshmi Das, the accused number 1 is the have many disputes between them and they
Are you disputing the signature?
My lord, signature is right, but
Can I
signed it on a blank paper, my lord.
How do I know? All these things you have to prove in the trial. How can I?
The petitioner is a widow, my lord. His husband was conducting those things. The Vijay Lakshmi Das, accused number 1, has taken 5 lakhs money to give Suryamani Tripathi, and Suryamani Tripathi assured to give them government job.
But you,
thereafter, when
the allegation is you have given an affidavit, which is the offending document, on the basis of which the complaint is filed. That affidavit contains your signature.
Yes, sir.
And today you are saying that I have signed in blank paper and all. All these things has to be
the contention in the affidavit 1cc case is also saying, sir. But at para
where is that? Show me.
17, page 17, para that being aggrieved by such a
17 years. Where does he say that blank paper?
No, not blank.
If the complaint says that were signed by in the blank paper, then you have a case. Show me that. Yes.
The para at page 18, running page 18 at para K.
Yes, read it.
That the accused number 1, that is the Vijay Lakshmi Das, who has
defame, malign, and tarnish the image of the complainant, intentionally prepared those false affidavit by using 3 persons. Using 3 persons. Then you are there. I'm the harm the reputation of the complainant. The accused persons are highly educated, measured, and well acquainted with the law and of the land. You participated with him.
No, I have not participated, but my
will not make no unnecessary.
Vijay Lakshmi was my lecturer, and I was the student. I was her student. And
that's the only point which is a bit favorable to you.
But that no, that taking that advantage.
I'll issue notice because it is a defamation. What do you say? Why
one thing, Lord. The case is now posted for charge. His appearance already in 205 dispense with. One of the accused made apology on the same ground. But he is discharged. He may be.
Why you have tendered apology and finished?
One of the co-accused already been discharged on the ground of same allegation, my lord. He made an apology petition, then his discharge application allowed. He may go there and file case is posted for charge, my lord.
You move application.
My lord.
See, one of the accused has tendered apology. He was
same allegation, my lord.
Same allegation. Because
accused number 4, my lord.
And another accused has been discharged.
Accused number 4 discharged same ground, my lord. He made an apology. That is not my knowledge. And another
2, 3, 4 and the victim of same.
The petitioner is seeking quashing of the entire criminal prosecution initiated by the opposite party number 2. Opposite party number 2. Opposite party. For release commission of offense for the so. Then counsel of the petitioner has taken me to the allegation made against his client by the opposite party and submits that no case under section 500 IPC is made out even if the contents in the complaint is accepted at its face value. And counsel for the opposite party submits that the accused number 4, who is also similarly situated like the petitioner, had tendered apology before the trial court. On the basis of the apology, he has been discharged. The matter is now fixed for filling up charge. at this stage, land comes for the petitioner seeks to withdraw the previous petition to move appropriate application before the trial court.
On the footing of the opposite
trial
of
court, trial court. Trial court, if such application go, the same shall be considered in the light of the order dated.
That
We have the
order
in the
order dated 17 1 minute.
in the light of
72 minute. 17 February has been discharged.
2025 pass in regard to the accused number.
He made an apology application.
Same in the same in the light of that. Yes, you render apology. Yes. Yes.
23.
Yes, Lord.
Lord, I have filed this application, my lord, for quashing of the FIR on the ground of compromise. 307 is the alleged offence and charge sheet has not been filed since till date, my lord. Charge sheet has not.
Injuries?
Injury, my lord, grievous.
Grievous.
Yes, my lord. That both the party will appear before your lordship.
And they appear, the grievous will, if they appear, the grievous will be simple or what?
No, no, my lord.
Then
that they.
Which part of the body?
That
Head-
both
head
are
injury.
Head injury.
both are, my lord, neighbor. And
Don't tell all these things.
And my lord,
If
civil
settlement
dispute-
means in 307, you only thing is you have to tell me that whether injury is simple or.
No, my lord, injury
And
is
which
cheap.
part of the body?
No, that is not-
What is the weapon used?
That
Iron rod.
I don't know. No, helmet try ಮಾಡಿದ್ದೆ.
No, iron rod.
That
The material. He has only filed the FIR.
I have filed the FIR copy, my lord, because charge sheet has not been filed till date. And my lord, they don't know ଦି ଭାଇ ଜମି ବାଡି ନେଇକି ଆଜ୍ଞା ବାଉଣ୍ଡରୀ ଡିସ୍ପ୍ୟୁଟ ନେଇକି ଗଣ୍ଡଗୋଳ ଗୋଟେ ଜାଗାରେ ରହୁଛନ୍ତି ଗୋଟେ-
reason may be, but
Aଜ୍ଞା,
307 in compromise.
that is the matter of record, my lord. I don't.
That's the problem.
My lord.
Simply
ସେମାନେ
note-
ଆସନ୍ତୁ
Simply issue notice status.
ଆଜ୍ଞା
Get the status report. Investigation status.
ଆଜ୍ଞା
Right.
I will file the requisite, my lord.
You file the requisite.
Obliged to lord.
Have you impleaded the informant? and
Yes,
the
yes, my
victim?
lord. Yes, yes. Informant is the victim, my lord.
Okay, let him get the status.
Aye.
Yes.
24.
The petitioner filed this case for quashing of the order of cognizance taken by the Lord and the trial court lordship.
Yes.
Well, the petitioner is the lecturer and HOD of Department of Political Science at Ranapur Degree College.
Yes.
However, the incident took place in the year 2022 and the informant lodged FIR against 27 persons. Against
The village committee.
Huh?
The accused person is the elected candidate.
No.
The
Yes, accused, but not the petitioner.
candidate. The informant wife is defeated candidate.
Defeated candidate.
He filed the election petition before the London court below.
Yes.
Why he had filed? Therefore, the village committee
Pressurized.
Went in
pressurized and he withdraw the case. Therefore, he lost the FIR. And the village, your lordship, the law is that village committee and Khap Panchayat, they have no jurisdiction to. This is the decision of this.
But so far as the petitioner is concerned,
How can you
he-
how can you force someone to withdraw the case and all?
my lord, he is not at all present at the village, my lord.
But,
Page 68, I filed all the documents.
You are the candidate.
No, I am not the candidate. My lord, I am not the,
Shakti Vaini judgment, I know.
I am not the
He is
candidate.
the member of that village committee.
Village committee.
Not member also. My lord, he is now working as,
Why don't you settle? You are a political leader. Why are you getting into all these things?
well, no political leader. He is a lecturer and now working as a HOD in a degree college.
But you are contesting.
No, my lord, I am not contesting.
No contesting. He
The other co-accused persons.
committee member, 27.
Okay.
No committee member at all. My lord,
You are the member of that village.
Yes,
committee.
yes, that committee.
no
Head
member.
of the village committee.
Yes.
My lord, not member at all. Nothing.
You are not saying that the name.
The allegation. Only
Come to the charge sheet then.
Charge sheet, yes.
only omnibus allegation.
Let us come to the charge.
Page
Yes.
60, serial number 26. His
60?
name is there.
60.
60 page.
Okay. Yes.
And the 26, Prashant Kumar Behra.
Yes.
His name is there, your lordship.
His charge sheet.
In the charge sheet, your lordship.
He is the one of the member. Before that, his name.
My lord, the
also-
entire allegation, page 59, your lordship. The allegation, my lord. Further, may permitted to, my lord.
Yes.
Further, on dated 28/5/2022 at 11 AM, while the secretary of the village committee Surya Narayan Swai, the vice president of the committee Bhaskara Sahu, the accountant of the committee along with the above mentioned villagers trespassed his house and
Your
threatened
name
the.
is Prashant Bera.
Yes, Your Lordship. That is only one allegation along with other all accused persons, Your Lordship. And I have filed the
No, no.
document.
Come to page 58, middle.
58.
Middle.
Yes, his name is there.
No, his name is there.
See, all the name including your name.
Yes, my lord.
Name got furious and assaulted him along with his family member.
Yes.
They also boycotted his family by threatening them for dire consequences. On the advice of his father, the informant did not report the matter to the PS. On 18/5/2022,
Yes.
again the above noted persons held a village meeting
Yes.
on the matter, and after commencement of the meeting, all the accused persons abused him. All these things, you are there.
Yes.
My lord, on
You are a
every
prominent
date.
person there.
My lord, on every date, 3 dates is there mentioned in the charge sheet.
I
On
will
every,
not,
in all the dates, Your Lordship, I have filed the college documents. I was invigilator in the college, page 68 onwards.
Plea of alibi is
yes.
a question of fact to be settled in the trial.
Yes, Your Lordship, but he is not at all present during the incident. In every date, all
That's
the
right.
date.
Plea of alibi is a question of fact to be established in the trial.
Yes, Lord.
I'll write that.
Yes.
Right. Petitioner is seeking, petitioner is accused in FIR number 22 along with, how many accused total?
27.
27.
Along with 26 other accused persons. Allegation of the petitioner also. Let accounts for the petitioner submits that the dispute, the allegation pertains to 3 separate incidents. Happened on 18/5/2022, 26/5/2022, and 27/5/2022. On all these 3 dates, the petitioner being a professor, head of the department.
Yes, Your Lordship.
Professor in which college?
Ranapur Degree College.
Ranapur Degree College has been attending the
Political
and
science.
he was not even present in the spot, present in the spot. On the basis of the plea of alibi, he submits that no case, the petitioner has been falsely implicated. However, perusal of the charge sheet, the allegation against the petitioner is very specific. Specific. And the plea of alibi, a question poised with facts needs to be fleshed out in the trial. Hence, I am not inclined to entertain this petition as they say. However, liberty is granted to the petitioner to resort to any remedy. That's law. Mr. Vishal appealing for the state has relied upon the judgment of Supreme Court 2018-7, which is 192. Shakti Bahini versus Union and submit that is the submits that the Supreme Court has Supreme Court in the state judgment has deprecated the practice adopted by the village committee to Khap Panchayat and etc. And this is one such case where the petitioner being the party to the village union. Village committee has indulged in pressurizing the informant to withdraw the case. He has initiated against petitioner initiated against one of the
Initiated that elected candidate, namely Manjulata Swami.
Wife of the informant.
Oh, yes.
Problem.
Yes. Yes, sir.
Challenging against the notice issued by the opposite number, OP number 4, my lord. IAC.
Yes.
Page number 13, my lord, next one. My lord, the petitioner company is pledging gold items to the bona fide customers.
Sorry?
pledging gold ornaments to the customers.
Manipuram gold,
Gold loan.
finance.
Annexure 1, my lord. Now the OP number 4 is
Only,
Gold
only summons are issued. 94 BNSS क्या है भैया?
94, that is
So much.
91, section 91 in the older.
91 of the CRPC, 94
91.
Yes.
90.
Old Act.
So what is wrong in it?
Wrong is, my lord, we are ready to produce the documents as required by the court also. If will
During inquiry also the police can ask for it.
yes, where 3D photographs you want to
Do it.
the limited period, my lord.
Do it.
And Annexure 4, similar case, this honorable court also directed.
Annexure 4.
Annexure 4.
Yes.
Page number 33.
Yes.
Running page 35. Learner counsel for the petitioner submits that the petitioner company challenge the action of the opposite number 4 IAC Jharsuguda Town Police Station by issuing a notice under section 90 CPC to mortgage by the serviceman. The grievance of the petitioner is that for the police information, the property in mortgage with the bank is stolen property, which is the petitioner has no knowledge at the time of accepting such property, which was sought to be mortgaged. Further submit that about the citizens' property, which are kept in police custody for years together and suffers huge wear and tear due to improper on keeping of such property. When the case includes, there is a huge erosion or depreciation. Rendering these articles issues, or sometimes it's special value, ledger value.
Yes, same order you want. Same order you want. Who are
We
you?
are ready to produce at the time of.
Who are you?
I am the petitioner company.
There also he is the petitioner.
There is also
similar annexure 4 रे जो order है ना, similar okay, allowed. Similar order, ना? ठीक होगी. Annexure 4. Annexure 4 is page 35. Yes.
56.
May I please your lordship? In this case,
Yes,
your petitioner challenge the order of cognizance dated 2/1/2014.
At the Vigilance Council is to argue this.
Yes.
They file it wrongly marked.
Wrongly marked to you. You tell me whether it is worth issuing notice or not. Let us see.
Special Judge Vigilance schedule for consequence proceeding thereafter, Lord. Basing upon the statement, 161 statement of
what are the offences?
Offences, my lord, under section 13(1)
Yes.
speedy prevention of.
Who are you?
I am the senior surveyor, Lord.
Yes.
Basing upon the statement under section 161 CRPC, my lord, but annexure
Of co-accused.
my lord.
Yes.
One statement of one Pramod Kumar Behra, my lord. Page 148. Can you place this?
Page
148, my lord. Annexure 2, my lord.
Yes. Your name is not there in the FIR.
My name is not in the FIR, my lord. Basing upon the 161 statement of records.
Allow the issue notice. Mr. The petitioner submits that the petitioner name was not in the FIR. However, during the investigation, the statement of one of the co-accused. Where is that? Page
148 of annexure 2.
148. 148. Statement of one of the co-accused, 148. What is the name of the co-accused? Whose statement?
Pramod Kumar Behra.
One of the co-accused, Pramod Kumar Behra. He is also co-accused.
Miller.
The statement of the co-accused, Pramod Kumar Behra, the petitioner has except the statement of the co-accused, there is no other material brought on record against the petitioner. Issue notice to what is this case? Charge sheet is filed only.
Charge sheet filed.
If anything happens, then you come. Trial started. Cognizance is taken. Where have you said? What is the case? Cognizance is taken. Yes. What is the case? Where have you said that? See, there are 25 accused persons. Then once I stay, then the other people will also take benefit. That's the problem.
Your Lordship asked me.
I am just issuing notice, let us examine short date.
Okay.
1 week. And supply the copy also. Mr. Mishra undertakes to supply the copy of the petition to the council for vigilance. Vigilance during the course of the day. Give it. And next week, notice. Yes.
28 to 27.
May I please, your lordship? My lord, in this application, my lord,
Yes.
this present petitioner filed this application challenging the order dated 26/11/2024,
Yes.
in which the applications which has already been preferred by this present petitioner was rejected by the trial court, that is additional district session judge cum fast track cum special judge, my lord, Kendrapada, that on the ground stated therein. Here is, my lord, that is the case, my lord. I have annexed all the document that FIR initially was registered.
376D.
376D. My name is there in the FIR. Thereafter, my lord, thereafter, my lord, charge sheet filed against me and this present petitioner along with 2 others. They were arrested and they were, my lord, in custody for some period, my lord. Thereafter, my lord, that charge was framed and
They face the trial.
yes, my lord.
They are acquitted.
Yes, two accused persons were acquitted, and my lord, that
He was
I know, I understand.
I was absconding. Thereafter, my lord, this present petitioner was
The
arrested.
gang rape case.
Gang rape case. Petitioner later on was arrested, and now, my lord, charge has already been, my lord, framed. Here, my lord,
Got the bail. Got the bail.
Yes, my lord. That 2 persons, they were acquitted, and these present petitioners got bail. On the ground, my lord, I have annexed the deposition copy of the victim, informant, and others.
Yes.
They have totally denied the allegation. Victim, my lord, PW4, page 59. That is the victim statement.
Now, what is the stage now?
Stage, my lord, these 2 who face trial, they have already been acquitted. I have annexed.
What is the stage in your case?
In my application, my charge is to be framed. For that reason, my lord,
I'll target the, you are on bail. I'll target the trial.
my lord, the problem is,
There
my
is no
lord,
question. It's gang rape.
a gang rape can say
At page 17,
2, sir.
Annex
Yes.
2, at page 17,
Yes.
the check has been issued in the name of some.
Kairos Petroleum Limited.
Yes, that is issued in favor of some catering service. Joy Kamal Catering.
Jay Kamal Catering.
And you will also see the page 13, Annex 1.
Yes.
The complaint has been filed by one Ramakant Mahanti. And in the complaint, he says at page 14, last 2 lines.
Yes.
On 31/5/2020, in the name of complainants, another proprietorship concern, namely so and so.
Has he given any power of attorney or anything?
He says that somebody else, in view of, there was a C&F agreement. C&F agreement, I have also given that. There, you will also see at page 18.
Yes.
Ramakant Mahanti is the party, Kairos and Ramakant Mahanti.
18, huh?
Page 18. It's between Kairos and Ramakant Mahanti, individual capacity. He says that a check was given in favor of.
In the name of someone else.
Someone else. And he files a complaint by saying that I am the proprietor and therefore.
Who is that gentleman? In whose favor you have given the.
Some catering service. Jai Kamal Catering Service. This is one point. He is neither a holder of the check nor holder in due course. The second point which I am raising is, in the complaint itself, it is stated that notice was served on me on 2/8/2020 at page 15.
2/8/2020. Yes.
At Roman.
Notice was issued to you or that service?
Notice was issued.
Catering service. Let us see.
That even though the accused received notice on 2/8/2020, at paragraph, last but one paragraph.
Can you just give me that notice? Whether notice was issued on behalf of that catering service or Ramakant?
No, this complainant.
Just check it up.
That I don't have the copy readily. I don't have the copy.
Do you have the copy? Just take it up. Then you have a case because he in the complaint he doesn't say that I am authorized by that service, catering service, whatever. He doesn't say. Rather, in the contrary, he says that it
was given in the name of somebody else.
Yes.
Copy I'm not having, but
shall I record your statement?
What statement?
Statement that the notice was issued by Ramakant Mandu.
Yes.
I'll record that. Yes. Petitioner, the opposite party number 2 has initiated the complaint case, ICG case number 3197 of 2020 against the petitioner for under section 158 NI. The senior counsel has taken me to the subject check which has been issued by the petitioner in the name of one Jay Kamal Catering Services. However, the complaint petition has been filed by the opposite party Ramakant Mandu. Then also further submits that even the statutory notice under section 138 bracket small b has been issued by Ramakant Mahanti. Insofar as Messrs. Jayakamal Catering Service is concerned, neither any power of attorney is being given to Ramakant Mahanti, nor any authorization has been given by said Jayakamal Catering Services to the to Ramakant Mahanti, bracket the opposite party. Issue notice to opposite party written on so. In the meantime, the proceeding before the trial court in ICC case number 3197 of 2020 state. Yes. I've said it.
There is one more. There are 2 checks. There is one more case is there. I have filed another CRLMC 584 of 2025.
That is not there.
Not there. That can it be listed or you will pass the same on?
No, it has to be listed.
Let
list it. Okay. Get this order so that I can get. Yes.
29.
May I please, Lord? Lord, without any proper inquiry, at the time of FIR, my Lord, the prosecution projected me as a house owner of the house, that is space 12, my Lord. But I am not the owner of the house, my Lord. I have annexed the ROR, that is space 15, my Lord. At the time of that is space 12.
Space 12.
Yes, my Lord.
Now, what are the offenses?
Offense, my Lord, NDPS, my Lord.
NDPS.
My Lord.
So,
At
what
the
are
time
the
of-
allegations? Let us see.
Yes, my Lord. The space 12, my Lord. During further inquiry at locality and the accused, it came to light that the accused called by one A. Chandrasekhar at Red Chindu, owner of the house, my Lord. But I have annexed the ROR, that is space 15, my Lord. That is recorded on A. Iswari, my Lord.
ROR may be, you may be tenant, you may be whatever. ROR will not decide.
My only prayer, direct to the
The
investigation.
contraband ganja is recovered from a premises.
My Lord. And
Police says that you are the owner of that premises.
Yes, my Lord.
On that basis,
Again.
you have been implicated.
And one principal.
And you are relying upon a ROR. ROR may be in somebody's name. You may be a tenant, you may be occupier, you may be. You don't know.
One principal accused, Mithun Nath is apprehended at the
I am not
court.
deciding a title suit here or
Not, my Lord, not title suit, my Lord. Only direction issued to the investigation officer to ascertain who is the owner of the.
He will do it, otherwise you will get benefit. Why should you?
Till then, my Lord.
Why are you making the investigating officer wiser at this stage? I don't understand. Let the lapse be there. You direct him how to do it. Let him file a charge sheet without investigating that angle. That is beneficial to you. You are making wiser. getting a direction from High Court, do this, do that. Why are you doing that?
Not the owner, my lord. Till then, no course action up to charge.
Oh, you tell that is the underlining.
Yes, my lord.
In a case of this nature, NDPS, how are you expecting that?
My lord, I am not the owner of the house, my lord. That is recovered from the house.
Let the police find it. Let him do it.
This is the allegation for me.
Then it's a good case for bail. You will get the bail. Show it, and this is the best case possibly for getting bail. What is the recovery?
Recovery, my lord.
252 kg.
200. You will get the bail. There is no conscious position. The ROR is there. Somebody else. You get immediately you'll get the bail.
Lord,
why are you trying a wrong method of no
anticipatory bail
coercive action?
that was rejected, my lord. That was rejected.
Where is that?
My lord.
This is a case for bail. You should get bail, not the quashing.
That is ABL PL number 1452/2025.
Oh, anticipatory bail.
Para 30.
Oh, anticipatory bail, who will give you?
That
was rejected, my lord.
Oh, then you try for regular bail. Surrender. Shall I protect you for 15 days? You surrender and get the bail?
Yes, my lord.
That's a better idea. Otherwise, he will be absconding and you will go reach nowhere.
Yes.
Within 10-15 days, let him appear and apply for regular bail.
1 month, my lord.
Not 1 month. I should not give indulgence at all after the anticipatory bail is rejected. Still, I am trying to do because, in fact, there is no conscious position. Therefore, I am trying to. Right on. Petitioner is an accused in FIR number so. Allegation so. The petitioner applied for anticipatory bail before this court. Where is that order? Show me.
Lord, that is order I will.
Show me that order.
1452 of 2025, my lord. ABL appeal number 1452 of 2025.
Give that order.
Yes, my lord. Just they do.
I need to see that order. If in the merit something is said, I can't say anything contrary to that.
Just
I'll pass it over. Get that order. Get that order so that, see, if I'll say something contrary to the already some observation is made, then it's not fair. Yes. Yes. One minute. Call Mr. Party. Continue. Taking into account the nature. Right. 1452 of the other petition. The coordinated venture is court-wide order dated 11/2/2025 has rejected the said application. Mr. Patil and counsel for the petitioner submits that the only allegation against the petitioner is the recovery of the contraband ganja from a premises, which alleged to be premises. The police, the allegation is that the premises, the petitioner is the owner of the premises. He has relied upon the ROR of the premises, which stands in the name of A. Iswari. On the basis of the same, he submits that the contraband ganja seized from the premises. The petitioner is not the owner of the premises from where the contraband ganja has been seized. Contraband ganja is seized. The investigation in the present case is still going on. The anticipatory bail application moved by the petitioner has already been rejected. Therefore, I am not inclined to entertain this petition at this stage. At this stage, Mr. Patil and counsel for the petitioner at this stage submits that his client would be appearing or surrendering before the court below on or before 20th of March 2022 and restored to the remedy available to him under law. Under law, will be led to the submission. The petitioner is granted liberty to petitioner. No course action can be taken against the petitioner till 20th of March, subject to petitioner surrendering before the court and the subject to the remedy under law. It may clear that no further extension in any application shall be granted to. At least I will protected you go on at regular way and
Be prepared.
yes. Yes.
Item 30. May please, your lords.
I am appealing for the opposite party complaint.
There is a case under section 130 NI Act. I am challenging the order. I am
Settlement.
ऐसे कौन से round है वो कोई?
3 grounds.
Not settled.
No, no, my lord. There is a specific 3 grounds, my lord. Lords, you kindly see page 13 order dated 13/1/25.
13?
13/1/25, my lord. The order taking cognizance, my lord.
Yes.
After introduction of the new act, my lord, the BNSS, page, lords, you kindly see section 223, my lord. That is BNSS, my lord.
What do you want to say?
That provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard, my lord. That is not in the previous, my lord, old act, my lord. Before taking,
You talk about 138.
my lord,
Why are
138.
you bringing general law into it?
No,
It's a
general
special
law.
statute.
That is a complaint case, my lord.
Complaint case maybe, but it's a special statute matter, 138.
No,
Why are you
the
bringing
cognizance should be followed, my lord. My lord, cognizance should be followed, my lord.
what is the check amount?
40,000, my lord.
Oh, you pay.
Lord,
What is-
kindly
we
see-
are wasting time.
And the magistrate, lordship, can the Banki magistrate can take cognizance of the
Oh, forget about Banki
jurisdiction is
magistrate.
different, my lord. Jurisdiction is different.
How many installment?
But
Two
jurisdiction,
installment. 20,000 pay and finish. Why are you wasting High Court time, Banki Court's time? That's only 40,000 rupees.
My lord,
You
there is a-
spend more time and money in this.
and it is
litigation.
barred by limitation, my lord. The second notice, cognizance
Don't-
cannot be, my lord,
Sir,
second
don't
notice.
see, if it is a bigger amount, I can understand. You can I can go into all this thing. Why are you wasting High Court's time and the court's time for 40,000?
Lord,
Right
see,
away.
that is the, my lord, since the magistrate is no authority and the offense is, my lord,
The complainant must be might have spent more in defending this matter. Just see the lawyer that side.
without jurisdiction, can my lord, magistrate pass
He
the
might have charged
order, my lord?
he might have charged more than more than the Don't do that, please. Two installment.
No, I'll take instruction, my lord.
What instruction?
Without his instruction, my lord.
It's a 40,000.
Lord, see, my
Two installment.
my lord,
Pay 20,000.
keep it, my lord. Friday, I will take instruction.
Yes. Right.
But today,
Come with the money and finish it up.
I will take instruction, my lord.
Here.
Let till today, my lord, file for the appearance, my lord.
No, I will not do anything. I will not interfere at all. Unnecessary. Don't do that.
But court again power nahi, jurisdiction nahi,
For 40,000 rupees, if you keep on traveling the courts, High Court and everybody, then it's not fair. Give it.
142 is very clear.
Give it. Okay. Friday.
My name may be indicated. I have filed my Vokla.
Friday, come with 20,000 rupees at least to begin with, and we'll see. Okay.
The beggar person, my lord.
31.
What you say, beggar person, and he is holding a checkbook. Huh? The beggars are also started using the instruments like this. Huh?
Different schemes of government, my lord.
That's all. Give 40,000 for you. What? Yes. Sorry, sir. 31. I'll do 31 then.
My lord, I myself is the revenue inspector, my lord. When I have been implicated in a vigilance case under section 13(1)(d) and 13 to reduce the 13(1)(d), my lord.
Yes.
Here is a case, the man is the Tahsildar. I am working under the Tahsildar. There is a misunderstanding between that the notification which is governing the field in order to pay the compensation, the conversion amount. There is a dispute. The allegation is that it has been 3 lakhs. How it is less than this? So you all are in connivance have done this. But my work is revenue inspector. I only give the report. I have no authority at all to decide how much money has get or not get or recover not get not recover. So I am unnecessarily implicated in the criminal case.
RIs are very powerful. You know that.
Sir, in this
RI can do anything.
Sir, only section 3, section 64 and section 70 of the Euler Act Warrant itself a court. So they cannot beyond this.
Now, what is the stage? Let us understand. What is happening now?
Now they are lodging FIR against me under 13.
So investigation is going on.
Nothing is going on. That is still is pending since last 10 years.
2018.
Sir, my prayer is that
Vigilance, huh? It is vigilance
so
case.
issue notice, my God.
1 minute. 2018 FIR, what is happening? Vigilance.
Kind of pass over or?
I'll just pass over, sir. I'll issue notice. Let us
Issue
see.
notice.
2018 FIR. I'll record your statement that nothing is happening. Yeah?
Right.
Let counsel for the petitioner. The petitioner seeks quashing of the Kotak Vigilance PS case number 33 of 2018, which was registered on 17/7/2018 for alleged offences punishable under section 13 is 20 so and so. And counsel for the petitioner submits that even in the present case, the investigation, the prosecution has, the investigating officer has not even filed the charge sheet as yet. Issue notice to so and so. Written will be to let us see. Okay, I'll just come.
Yes. Well, one FIR was lodged in the Soro police station, and same was registered under section 323, 294, 506, 34 IPC, and under section 3, subsection 1, clause R, and 3(1)(s) and 3(2) of the SC/ST of Prevention of Atrocities Act, my lord.
Yes.
The final form was submitted. After final form, that the opposite party filed a protest petition. Okay. The case in the FIR and case in the protest petition are quite different, and the witnesses, 6 witnesses were examined.
You want to set a new case?
New case. Their cognizance has been taken under section 506.
Let us see the FIR. What are the allegations in it?
At page 17, my
yes. Page 12, come, just read it.
No, page
17?
No, page
14.
11, 12, 13.
Up to 40.
12, my lord. ଲେଖିବାର କାରଣ ଏଇକି ଯେ ଆମେ ଦରଖାସ୍ତକାରୀ ପ୍ରତାପ କୁମାର ସାହୁ ପିତା ରତ୍ନାକର ମୁଦୁଲି ଗ୍ରାମ ଛତ୍ରପୁର ପୋଷ୍ଟ 16 ୱାର୍ଡ ନମ୍ବର 9 ଜିଲ୍ଲା ବାଲେଶ୍ୱର ଅଧିବାସୀ ଅଟୁ ନିବେଦନ ଯେ ଆମର ଜମି ଜମାରୁ ଯିବା ପାଇଁ ନକ୍ସାରେ ପ୍ରତିପକ୍ଷ ଅନିଲ କୁମାର ଦେ ପିତା ରଘୁନାଥ ଦେ ସା ଛତ୍ରପୁର ପୋଷ୍ଟ 16 ଜିଲ୍ଲା ବାଲେଶ୍ୱର କୌଣସି ଚିହ୍ନଟ ନଥିବା ସ୍ଥଳେ ପ୍ରତିପକ୍ଷ ବାରମ୍ବାର ଗଣ୍ଡଗୋଳ ମାରପିଟ ଗାଳିଗୁଲଜ କରୁଛନ୍ତି। ଆମ୍ଭେ ଏ ଘଟଣା ଭଦ୍ରଲୋକମାନଙ୍କୁ କହିବାରୁ ଆମ୍ଭ ଉଭୟ ପକ୍ଷ ଲୋକଙ୍କ ସହାୟତାରେ ଏକ ବୈଠକ ବସିଥିଲା। ସେମାନେ ସମାଧାନ କରି 7/5/2023 ତାରିଖ ଦିନ ଉକ୍ତ ଜମି ଜମାର ସ୍ଥିତାବସ୍ଥା ରଖିବାକୁ ଉଭୟଙ୍କୁ ପ୍ରକାଶ କରି ଏକ ନିଷ୍ପତ୍ତିନାମା କରିଥିଲେ। ମାତ୍ର ପ୍ରତିପକ୍ଷ
This is regarding some illegal construction and all. Yes. Come to the protest petition.
You also kindly no, this cause of action arises from. ମାତ୍ର ପ୍ରତିପକ୍ଷ ଭଦ୍ରଲୋକ କଥା ବେଖାତିର କରି 15/5/2023 ତାରିଖ ଦିନ ଆମ ଚଳପ୍ରଚଳ ରାସ୍ତା ଉପରେ ପ୍ରତିପକ୍ଷ ଘର କରିବାକୁ ଇଟା ବାଲି ଚିସ୍ମାନ ଗାଡ଼ିରେ ନେଇ ଯାଉଛନ୍ତି। ଆମେ ପ୍ରତିପକ୍ଷ ପ୍ରତିବାଦ କରିବାରେ ଆମ୍ଭକୁ ଶଳା ଛୁଆଁଶୋ ହାଡ଼ି ତମକୁ ଛୁଇଁଲେ ଛୁଆନ୍ତ ଛୋଟ ଲୋକ ମୁଁ ଇଟା ପକାଇଲେ ମୋର ଏବଂ ଏତିକି ଦିଶି ଧମକ ଦେଲେ।
15/5/23. Okay.
15/5/23.
Let us come to the protest.
Then you will also kindly come to protest petition at page 17, my lord. ଭଦ୍ର ବେଖାତିର କରି ଗତ 15/5/2023 ଦିନ ଆମ ମୁଦେଇ ଚଳପ୍ରଚଳ ରାସ୍ତାର ମୁଦାଲା ଅନିଲ କୁମାର ଦେ ଘରି କରିବାକୁ ଇଟା ବାଲି ଚିସ୍ମାନ ଠୁଳ କରିବାକୁ ଥିଲେ। ଠୁଳ କରିବାରୁ there I was transporting the materials to my land. There here
same, it is pertaining to the same incident.
Incident same କରିବାରୁ ଆମ୍ଭେ ମୁଦେଇ ପ୍ରତିବାଦ ମୁଦାଲା ଆମକୁ ଆମ ଅନିଲ କୁମାର ଦେ ଆମକୁ ଶୋ ହାଡ଼ି ତ ଛୁଇଁଲେ ଛୁଆନ୍ତ ଛୁଇଁଲେ।
What is the difference? The FIR and same.
They are, my lord, they say that I was transporting.
Oh, this
Here
small
I
variation.
have piled, my lord.
So
Here,
small,
there-
he's not putting forth altogether a different case.
My lord, you will also kindly see that.
And in the FIR, you can't write everything exactly what had happened. The incident happened on 15/5/2023.
Then you will also kindly see initial statement of the 204.
Okay, let us see.
Next page, aspect 19.
Yes.
On middle, my lord. On 15/5/2000, Anil Kumar, there was transporting sand. Bricks.
The transporting
and
or
metals
keeping
through
of-
my land, my lord. Through my land. When I protested, he abused me as so and so, my lord. This is the case.
Then you are only trying to point out the contradictions.
Contradictions, my lord. Then you will also kindly to the date of incident, the time of incident.
Yeah.
The witnesses say, I have given, my lord, that the witnesses time is different. One witness say it is at 10, another witness say at 4:30 p.m. 4 to 4:30 p.m. my lord.
Oh, these are contradictions, and that contradictions at
You
this
will
stage
also
of
kind of-
cognizance. How can I go into all
My
this?
lord, that only they said that is no independent, only one independent witness is, has been examined, and there the timing is not same, my lord. You will also kindly final form was submitted by the police.
That's right. Final form is so.
You will also kindly see that at page 26.
I'll just issue notice. Let us see if they can come and settle, because the allegations are very minor. Some small misunderstanding merely because they are.
Small misunderstanding. Now I have
So therefore, I'm issuing notice, being them, try to settle it out.
Yes.
There's nothing serious about it.
No serious.
If there is no, only you were trying to put some materials there, and they came.
No, I was transporting to my land.
Whatever transporting or keeping.
Our land, that was the dispute according.
You are trying
I am not
to
fighting.
obstruct their.
They are obstructing. I was not obstructing.
That can be sorted out. Yeah. Okay. I'll issue notice. Okay. Issue notice, written information.
Further proceeding.
Yeah.
For timing is sorted, maybe.
Sort it. Next week I'll.
Till then.
Once he comes, then I'll send it to
Till
mediation
then-
and finish it up.
Till then,
Yeah.
further proceeding.
Oh, only cognizance is taken. Why further
Taken
proceeding?
Further proceeding may mistake.
Then once I'll
it
pass
will-
that order, then this matter will be pending for.
No, you
5,
must
6
fix
years.
it. I will finish it, my lord.
Next week I'm issuing notice. Bring them. I'll finish it up next week itself.
You lost your picture only till then, my lord. Now charges frame, charges frame.
If charges frame, I can't quash it. I can quash it. Everything. I'm making it clear. Bring next week. File the process immediately.
Yes.
Bring him next week. We'll settle it here.
Copy.
Give the copy. Give the copy.
State.
And service through IO also. Service through IO also.
Yes.
Dekho, service through IO. Normal process as well as through IO. So that we come.
This contract is a final form was.
It will be settled, sir. There is nothing. Through IO, Sir, sir.
Copy.
I will give the copy.
Yes.
Course of the.
Give one additional copy so that. Give an additional copy. Yes.
Tomorrow.
53.
Here,
Yes.
I wrote a limited grievance below.
IAC duty. Yeah. Yes. Yes, sir.
The petitioner is proprietor of one Bharat Trading Company having a registered office at Chhattisgarh in the state of Raipur in the state of Chhattisgarh. On the date of occurrence, he was transporting he was valid invoice, valid transit permit, everything. He was transporting 300 quintals of mahua flower from Chhattisgarh to Jharkhand by Keuzar.
Yeah.
On the way, the vehicle got disturbed, for which was seized and all that. Thereafter, the vehicle was billed in favor of the petitioner. I am not made accused, the driver was made accused. And the mahua flower is kept pending since then. And challenging the same, I filed a 457 application before the SDM Keuzar. That was registered 168 of 2024.
Show me that order.
Yes, my lord. And it was rejected. And
457 application.
yes, my lord.
Yes. Release of what?
CS space 11, my lord.
11.
While the 457 application was pending, the learned court in session about the matter made queries from the IO with yes, with the reference subject cited above, I am submit required information as sought for by the honorable so and so. The person Tarachand Agrawal, the registered owner of the seized articles. The referred seized articles are not required for further investigation. Confiscation proceeding initiated so and so, then article not lying in Keuzar exchange, so and so lying with the one
What are the offenses? Let us see the
Yes, my lord.
offenses.
I've given the
Orissa Excise Act.
Yeah? Orissa Excise Act.
He praised for
Why don't you participate in the confiscation proceeding?
My lord, he praised only early disposal of
Again,
revision pending before the
disposal of
settlement.
the 457
That is the
application.
prayer.
Oh, your application.
My lord.
Yes, it was
But
rejected.
see,
Page 15.
I understand, sir. You just tell me if the confiscation proceeding has already been initiated, you would participate there.
Yes. Well, there. You know, see page 16. I filed the 450, revision assailing the order passed by SDM. It is pending since, because file on
But you are
24/7.
you are pursuing a wrong remedy.
No,
If confiscation proceeding has already been initiated,
before
go
the authorized officer.
participate there.
No, yes, that is it. The revision is pending to let the sessions could be directed to conclude
His
the
prayer is
semi-critical
to early disposal of revision pending before session judge.
A revision is filed when?
My lord.
Revision is filed 21/7/2024. It's not even delayed. It will be decided.
No, it is.
We can't control the proceeding of the trial court in every stage.
No.
You know,
No, it is filed since 21/7.
what will happen? You know, if direction is given, out of pressure, the trial court will reject it.
No, let him
Safest
pass
thing
any
is
order.
reject.
Allow reject.
What will you get?
He is no other option, but kept pending since because Mohaflar will be subjected to that.
Why are you rejecting?
My criminal. I'm sorry. Let my friend to take instruction.
Invite to this problem. I allow it, but
Let the revisional court be directed to conclude the same with the stipulated period.
But petitioner is agreed by the petitioner is seeking a direction from this court to the Court of District and Session Council for disposal of the revision petition being criminal revision number 15 of 2024 for disposal. The revision petition was filed on 21/7/2024 and the same is pending for consideration. And then we see consideration. Next further. Since the prayer made by the petitioner is an innocent prayer, deserves merit. Accordingly, the present petition is allowed. Where it is pending?
The session judgment. District and Sessions Council
is directed to do and to see that the criminal revision petition number 15 of 2024 is disposed of as expeditiously as possible. With this observation, the petition is disposed of. Yes.
Some time frame that will. It is pending.
Time to are you unnecessary bargaining risk? And you'll simply dismiss it. Don't do that.
Because Mohapla is subjected to yes.
That's much indication is
since May, almost 10 months left.
Do it now. Yes.
Petition challenge the order dated 16/12/24, my lord. But the petitioner prays for release of his vehicle, my lord. The Warrant court will allow this and put a condition that the petitioners are furnished cash security 1,77,000, my lord.
Vehicle release,
my lord. At page 12, my lord, annexure 1. At that time, the vehicle has not been insured, my lord.
Bolero,
my lord. I want to submit, my lord. After the release of the vehicle, I will get the vehicle insured, my lord. There are submit the documents before the Lornet court.
No. See, nowadays what happens is even if you take it out the vehicle from the showroom, insurance is fast thereafter. It will come to the road.
My lord, I will.
Don't make the court to that. While going from there, if you met with an accident, what will happen?
That is the case, my lord.
Once you come out, if some accident happen, do you know that? Anything can happen. How can the court will allow you to ply the vehicle in the road without there being insurance? You tell me. Insurance is must.
My lord.
How can a court will be a party to that?
Condition number 1
you do insurance and take it. That's what the court says.
My lord. Condition
court can't allow you to ply the vehicle in the road without there being any insurance.
Condition number 1
I can give you time.
My lord.
For you get the insurance done, then you take the vehicle.
My lord.
Here, my lord, 1 lakh some order has been awarded for compensation due to having without insurance, he met an accident.
Why that's the problem.
And he want to waive out the casualty.
That is the case, my lord.
Get the insurance done.
My lord.
Get
2 weeks
the
after.
Huh? Get the insurance done and tell the court
My lord.
that insurance is done. Thereafter, I'll give you that liberty to move application. And counsel for the petitioner. And in this petitioner is seeking modification of the
Condition number 1.
condition imposed by imposed by which court? Imposed by
SDGM both.
Both. While its order dated 16/12/2024, while releasing the Bolero vehicle, the condition number, what is that condition?
1 page 12, my lord. Last
Page 12.
one.
The petitioner is agreed by the condition number 1. Condition number 1, which reads as an condition. Let counsel for the petitioner permission which doesn't market counsel for the petitioner submits that how much time do you want?
3 weeks, my lord.
Submits that within 4 weeks he'll make sure that the vehicle is insured, vehicle insured. Once the insurance of the vehicle is done, then the liberty is granted to the petitioner to move an application for the trial court for variation of the condition by which he is agreed. He is agreed. Accordingly, the present petition is partially allowed with the liberty as present. Within 1 month, you do the insurance. Thereafter, move an application for variation.
That are condition number 1 again.
Such application is moved. The same shall be considered on its merit. Okay.
Obliged.
Yes. Yes.
35.
So if I may please, your lordship, my lord. My lord, this is an application seeking the NBW that has been issued against me to set it aside on the ground that first it has to be ideally summons.
How many of you are there?
My lord, I am one here.
You are on bail?
My lord, I am the father of the deceased. The allegation is this, that my...
You tell me, I'll set aside, but tell me, you are not, you are
No,
absconding.
my lord, I never knew that there was a case instituted against me.
Okay. Right on. The counsel for the petitioner submits that the charge sheet has been filed again.
Charge sheet has been filed showing me as an absconder.
Charge sheet in the, you are not an accused in the FIR.
My lord, against unnamed persons.
Okay. Although the petitioner was not named in the FIR, however, the charge sheet in the present case has been filed on 27/7/2024, showing the petitioner as an absconder. Pursuant thereto, NBW has been issued against the petitioner by the order dated 22/8/2024. He seeks indulgence of this court, quashing the said in order dated 22/8/2024. There is a 25th. 25th.
My lord, 41A has been given to everybody else. That has been extended. The lordship may kindly see the implemented order. Everyone has been extended 41A. My lord would see page 40.
It's all right. You go and tell that.
My lord, I'll surrender.
25th?
My lord might not surrender. My lord, I would move an application for bail first, anticipatory here.
25th and resort to the remedy under law. Let counsel for the petitioner further submits that all the accused persons have been served the notice under section 41 capital A of CRPC. In that, in view of the same, he will be moving application for grant of bail. If such application is moved, the same shall be considered on its merit. Yes. Next.
Gratefully, lordship.
36.
Yes, sir.
May I please, Mr. This is a Belgium matter, my lord. The petitioner
Take the dates. That's all.
My lord. The order date include order date 15/4/2024, my lord.
Bail date, you tell me.
Bail date.
Do you have the dates? Don't delay. Tell me the 2 dates.
No.
Why are you wasting time?
Only NBW is there, my lord. And paragraph 6, he has written only.
Kindly see annex 3, my lord, page 19, my lord.
You tell me whether you are on bail or not. Tell me.
Yes,
the
my
dates.
lord.
Tell me the dates.
By granting my the code below, my lord.
Tell me the date, sir.
He has not mentioned.
Not mentioned.
You on bail. Yes. 15/4/2024 500 yes.
37.
May I please your worship. NBW issued on 16/8/2024. He was on bail on 22/7/2021, your lordship.
500 yes.
38.
NBW issued on 12 December 2020.
Loud
5/12/2024 NBW issued.
Yes.
And he was released on bail on 13th March 2023.
500 yes.
Obliged.
Carefully file the don't trust.
NBW dated 12/8/24. He was on bail by 22/8/2019.
22/8/2019 okay. NBW
Bail.
NBW is 12/8/2024 okay 500 yes.
40.
NBW issued on dated 21/11/2024 and he was on bail on 16/7/2014 that I have given in
500 yes.
41.
Thank you. And he was dated 29/11/2024. And he was on bail minor 5/6/2023.
500 yes.
42.
NBW on 12/11/21. Bail on 23/9/2013.
21 NBW 21 na?
No, 12/11/2021, lordship.
21 na?
21.
Okay 1000 yes.
53.
Lord, the date of NBW is 28th September 2018. Bail was granted on 9th of
9/11/20.
2011. The advocate for the accused did not appear, my lords. That is
Okay sir all right 1000
54.
NBW issued on 4th December 2024 and he was released on bail on 22/8/2022.
500 yes.
Obliged.
5.
May I please your worship. 24/2024 NBW was issued. 16/3/2018 he was on bail, your lord.
500 each.
46.
My lord, 24/2024 NBW was issued. 11/6/2013 he was on bail.
500
57.
5 petitions are there. NBW was issued on 28/2/2023 and bail was granted on 24/1/2019.
500 each.
48.
48, my lordship. NBW was issued on 25/8/2022 against the FIR. Against the FIR.
500
55/8/22.
okay. Charge sheet filed absconder huh? Charge sheet filed is an absconder. NBW issued on NBW issued on 25/8/2021 1000 yes.
49.
49, my lord. NBW was issued on 14/3/2024 and bail on 19/9/2022.
19/5
19/9/2022.
19/9/22.
okay 500
50.
Pardon, my lord, item 40.
don't mention between tell us yes.
That's NBW issued on 28/3/24 as bail on 27/1/24.
24 500
check bounce because I'm convicted and the appeal I have got.
yes, all right, 500
51.
May I please? On prayer of IO, the NBW was issued, my lord. Annexure 3 is the same order passed by your lordships, my lord. Annexure 3, my lord.
Annexure 3
First or second or same day, my lord, parity. Same day parity, my lord.
same order कर दो annexure 3 देखी कर दो yes.
52.
52, my lord. NBW dated 13/12/2023, my lord. And the previous, my lord, is 16/11/2021.
23
yeah. NBW also 13/12/23.
okay 500
53 bail dated 6/8/24. NBW 16/1/25.
25
25.
okay 500 each.
54.
54 release on bail 6/8/24 and NBW issue 16/1/25.
25 500 each yes. ये 500 each local high court bar no local दे दिया
My lord, in this case, my lord, next order is posted for 22 March 20. First date, my lord, report. My lord, not this.
को देना
20 54, my lord, item 54.
54, huh? 54.
Yeah. Next date as posted, enrolled issued 16/25.
Undertakes to appear before the court on the next date of hearing. That is on
22, my lord.
22
March.
2020. Okay.
53 item also.
53 also same.
Same, my lord.
53 we got those 22. Yes.
55.
Yes. Yes, sir.
Here, challenging the judgment in second April, madam.
You review, huh?
Review, madam.
Yes.
My only point is, my lord, now kindly come to my review petition, page 9,
9. Okay.
round number 8.
9, huh?
9.
Where 9? Yes, sir.
These documents, these 12 documents referred in ground number A, so that the appellant is the son of Sheikh Israel.
For that, the Honorable will consider the following documents which consistently
And all.
Yes, these documents you are relying upon.
Relying upon.
Yes.
All the documents are exhibited documents. These documents have not been considered by the Lord Assembly.
Not considered.
Not considered.
Not considered is not the ground.
Not even referred, my lord.
Maybe that's not a ground for review.
It is a judgment.
So,
Old judgment.
not considered by a particular point.
Even if not referred, madam.
But those things are in appeal, you can do it. In the how
appeal se ground niya hitala. Substantial question lo tari upare hitila appeal admit hitala.
then
at the time of passing.
just see 47, order 47, whether in which exception you fall.
I will prepare and I will file another judgment.
Show me which part of the judgment, sir.
I have not.
Which part of it?
And there are similar judgment. I will supply other 2 judgments I have.
You want time. Okay. Simply adjourn.
Next week.
See, your case is there are few documents you have exhibited.
There are 12.
Those documents are not referred to by the by the single judge. And you came in appeal is dismissed. Isn't it? And you are filing review. That is not a ground for review.
I will file judgment to that.
Because these documents are not referred, then you go and to the right court and say that, see, these are the document exhibited document. If a document is could not be considered because it was not available, and you subsequently discover, that is a ground under.
No, it is.
But it's a part of record is not considered. What to do? Non-appreciation of evidence is not a ground for review.
I will supply.
Please.
Next week.
Get some. Yes, yes.
Get me.
Yes. Your precise case is non-appreciation of the document. Is it not a ground for review?
Right.
Yes. See. Yes.
56.
Yes. Password.
Yes, sir.
The review petitions are filed. It's pending 2009. Password correspondent. Who you are for the who is appearing for the opposite side? Private parties, huh? Yeah, 2009 these review petitions are pending.
Yes.
Absolutely, there is nothing. Password correspondent.
59.
Very closely.
Yes, sir.
Notice and question of limitation has been issued, and all the parties have appeared also. And
Yes.
only contesting opposite party 8, my lords.
8.
8. Yes, filed an objection to that.
You are appearing for 8, sir?
Yes, my lord.
Yes.
He had no objection, the delays condoned. Delays too much, my lords.
Delay of how many days?
Delay of around
Huh?
21
years.
21?
2 years.
21 years.
Yes, my lord. The question will, my lords. The petitioner and the opposite
No,
party all
but
are
delay of
person.
21 years, I can only condone by recording his consent. Beyond that, I can't do it. If you give consent, I'll record the consent and do it. Because it's a private dispute between both of you. Otherwise, sufficient cause has to be shown.
All brothers and sisters, my lords.
Maybe, but then I'll.
No.
Actually staying when the elder brother, the will actually not been granted probate at my behest. In fact, is outside the residing outside the country. That's what I have stated.
Then there is why don't you settle then?
That's exactly once it will be taken up, your lordship will
And I will send it to mediation immediately.
Yes,
I'll send it to
immediately.
mediation.
That's
The
exactly
party-
the process.
Yes, yes.
delay
That's
may
the
be
best
conduct-
way of doing it.
Yes, my lord.
Unnecessary. The
And parties to be appear before.
this is the present petition is arising out of a probate proceeding. The parties are related to each other. There is a scope of Mr. Rathod and counsel appearing for the contesting respondent number 8 submit. There is a scope of settlement between the parties, and the counsel for the petitioner is also having the similar view. In view of the aforementioned, the matter is relegated to the High Court mediation, sir.
High Court mediation.
High Court mediation, sir, and appear through VC. I'll record that.
Yes,
Appear through the parties. They are staying abroad and whatever.
Lordship may.
Mediation, sir. So parties are at liberty to even appear through video conferencing mode to explore the possibility of the settlement, awaiting the mediation report, lease the matter on. Yes.
May I just pray one thing? Mr. Bhuya is probably Vivekananda Bhuya is senior advocate. He could mediate on the there. That would be because it's a high stake situations, and I just taken.
I agree.
No. What do you suggest?
Let Mr. Vivekananda Bhuya,
Senior advocate, Mr. Bhuya be.
You want a senior advocate to be the mediator?
Yes, my lord. So that the things having.
But unless I take the consent, I can't.
Yes, I agree, my lord. I agree. All parties are here, my lord.
I don't want this.
Okay, the party.
And fees, your lordship may fix. There is no issue.
Okay, yeah, it's kind of a arbitrator now.
Well, that's true. Well, there's a family dispute,
Yes,
in fact.
since, the council appealing for the parties conjointly request to appoint
Mr. Vivekananda Bhuya.
Mr. Vivekananda Bhuya,
Senior advocate.
the senior counsel of this court for mediation, mediation. Super mediation for mediation, and both the councils have also submitted that they have taken. You have taken consent.
No, I have not taken.
They have already. I'll record that they have taken the consent of Mr. Bhuya for the same. Regarding head to the submission made in the bar, I request Mr. Vivekanand Bhuya, senior counsel, to conduct a mediation process between the parties and explore the possibility of a settlement and submit a report before this court by next date appearing. This matter from awaiting the mediation report. Let us see the council.
The delay may be condoned.
Delay I'll not condone. Wait. If
even
no, if the mediation is successful, I'll condone the delay and record it.
Okay.
Mediation is not successful in that case. What to do?
Obliged.
I have to 21 years. I have to write something. I can't do it like this. But I hope the mediation.
It will work out.
On the basis of mediation report, I'll dispose it up, condoning delay and all.
Yes, my lord.
Yes.
Well, before your lordship starts, that 58, somebody has taken an adjournment. My lord, may kindly see the last order.
58?
Yes, your lordship may kindly. My lord, your lordship may. My lord, may kindly see the last order.
What to do, Mr. Bose, if your friend is.
My lord, last occasion he was not present.
Yeah.
Your lordship, I had made a mention before your lordship that keeping the review pending, they are stalling the execution. That's why your lordship fixed it to 20th of February to.
Then I'll pass it over, call him.
Well, he will not come because he's somewhere else. Your lordship may take it up day after tomorrow because your lordship may kindly see the last order.
What to do? Your brother colleague in the bar mentions in the morning, says that I have personal difficulty. I adjourn it. It is minimum requirement is the other side is to inform.
Yes, he should. Well, your lordship may kindly see the last order, whatever your lordship.
I have seen that, but what to do?
They are not appearing regularly. Avoiding your lordship.
Keep it on Friday. Keep it on Friday. Friday. Right.
Because by this process, they are stopping the
matter,
execution of.
write down, the matter was mentioned by whom? Mr. Samantrai. Mr. Samantrai, learned counsel for the petitioner for an adjournment in the morning session. Mr. Bose said the stays at
He was talking, he did not inform me.
Mr. Bose subsequently appears and submits that he has not been informed by Mr. Samantrai. He further submits that due to the pendency of the present review petition, the petitioner is taking adjournment before the execution court. Execution court. Hence, lease the matter on Friday for disposal. Yes, I have recorded that.
Last order, if you are also lordship, your lordship ensure that.
What to do? I don't see the proceedings. Somebody mentions in the morning. I have.
I am not making any.
But you see, you have to tell your brother why has he mentioned like this, and intimate this order. Mr. Bose undertakes to intimate the today's order to the learned counsel for the petitioner. Yes, take the order and intimate it. Yes.
60.
Item 60, your lordship, the limitation petition already filed, my lord. That is IA number 155 of 2020.
155.
Yes, my lord. Today we are filing.
It's not there.
Today we are filing.
Counsel for the petitioner submits that he has filed a application for seeking condonation of delay for filing the appeal. First appeal, FAO. The same is not on record. Is directed to place it in record.
And I pray 3 weeks time to file the original deposit receipt, my lord.
Original, and he further takes 3 weeks time for placing on record the original receipt of deposit of the above amount before the commissioner. Lease the matter after 3 weeks. Yes.
May I please, Your Lordship?
Yes.
This is a restoration application, my lord.
Yes. How much delay?
The delay is more than 7 years.
Then
the only the government is a party, my lord.
Government may be a party, but 7 years delay, how will you explain?
Yes, my lord.
Let us see the explanation.
Lord, in fact, the petitioner number 5 was looking after the case, as he could not keep the track with the previous lawyer. When he came to Cuttack to know the status of the case, didn't found his previous lawyer. Therefore, he personally comes to this Hon'Ble court and applied for the certified copy.
You slept over for 7 years, and thereafter you, the fine day, you come out and keep on asking your lawyer. These things are not explanation. 7 years delay.
My lord, he himself.
If he
No
will,
explanation. There is no explanation.
there is no explanation.
Only I came to know in 2024. My lawyer not attend.
What to do?
Only matter 2003.
My lord, there is a.
On merits, do you have anything?
Yes, my lord, there is a sealing case, my lord. The order is impugned in the writ application is a sealing proceeding.
Sealing proceeding.
Yes, my lord.
What can I be? I don't think I feel. This order was passed. Where is that? No, this one.
No, only the government is a party, no private parties is there, my lord.
But what can I do? How will you explain the delay? That's the worry. Yes.
Well, that is the reason that he could not keep the.
I simply adjourn it to next week. If you can file a better affidavit explaining delay, I may help you. Because this is not the sufficient cause.
It is a fact, my lord. He himself came to.
Then I'll pass the order. Then I'll pass the order.
Yes, I am leaving it to.
Okay. Give it to me. Sufficient cause. Give it to me. Okay, I'll pass the order.
62, my lord, are not virtual mode, my lord. Here,
yes.
This application for restoration of the criminal case, which was dismissed for default non-prosecution.
Delay, how much?
In fact, the CRLM criminal matters, no delay is wanted out.
Your Lordship,
Your Lordship, he has not annexed the petition for which he is seeking the restoration. It should be annexed first, Your Lordships. The matter has become infructuous, Your Lordship. I'll explain how. So let him annex that petition because he's an absconder, Your
Yes,
Lordship.
Mr. Mahapatra, is that matter is main matter is infructuous.
Not infructuous. I'll
No,
explain,
my
Your
lord.
Lordships.
No, my lord. No, my lord. That is not correct.
Let him
Here
let
the petitioner has challenged the issuance of NBW at the first instance when he was shown not arrested in the charge sheet. There was no summon was issued. And the first instance is contrary to the decision of the Indraman Goswami, non-bailable warrant was issued. Therefore, he challenged that order of issuance of NBW. That in that case, interim order of stay of NBW was granted. Subsequently, because of the dismissal for non-prosecution, the interim order is stood vacated.
Your Lordship,
No, see, NBW, now what is the position? You are,
Your Lordship, he is an absconder. Your Lordship, he has an absconder and proclamation has been issued. Now he's a proclaimed offender.
So
okay, it's all right. All right. Yes, Mr. Mahapatra, when are you going to surrender? You tell me. I'll set aside that NBW. Let him surrender.
No,
You can't execute.
Lordship, the Supreme Court is saying that anticipatory bail cannot be filed by proclaimed offenders. So he's seeking an indirect relief, Your Lordships. There is a direct judgment of the Honorable Supreme Court also.
See, there is an NBW. Why are you not executing?
NBW, I will tell you, Lordship. Let me explain.
Yes.
Your Lordships, when the NBW was issued in the year 2018, after that, he did not attend any of the proceedings for 5 years. When Honorable Justice Mr. Muralidhar was there, he thought that I'm not going to get a relief. Therefore, he didn't go intentionally. Then it got dismissed by default. Now, Your Lordships, proclaimed offender has already been issued proclamation and he is an absconder under 83. Supreme Court is said that anticipatory bail is not applicable as far as 83 proceedings are concerned. He is disentitled for anticipatory bail. Now he's seeking an indirect relief, Your Lordships.
No, I am not giving relief. I am saying that let him go and appear, resort to the remedy available to him under law.
But he cannot
Otherwise,
appear now.
why don't you execute the NBW?
Because
what will happen? No, you, Mr. Naik, you tell me what will happen now.
I did not execute.
This will remain like this only.
I'll explain why. We could not execute the NBW, Your Lordships, because there was a stay operating for 5 years, and in the interagnum 5 years period, he never went there, Your Lordships. Now,
see, it was dismissed on default when?
Your Lordship, may ask him when he filed it. And in the interregnum 5 years, what did he do? And how many times he went to the court?
When was it dismissed?
2023, madam. One important thing
within these 2 years, why have you not executed? You could have executed. There was no stay.
Just 1 minute, 1 minute, Mr.
1 minute, 1 minute.
He's asking me a question, let me answer it. Court is asking me, let
1
me
minute,
answer.
Mr. Mahapatra, let us find out.
Your Lordships, we could not execute the NBW because he absconded, and after absconding, Your Lordships, we issued notice under 82. Now he's a proclaimed offender.
Yes.
Now there are judgments of the Supreme Court that proclaimed offenders are disentitled for anticipatory bail. So he's seeking a relief of anticipatory bail under the guise of 482 now, Your Lordships, when he's not entitled for that relief. And we could not execute it because he absconded, Your Lordships. I'll file an affidavit.
1 minute. Now, what is the course now?
Your Lordships, course is that this petition, Your Lordship, is not maintainable, Your Lordships.
You will not execute you will not arrest him. He will keep on absconding. Rather, better would be, I will bound him to appear before the trial court and let the trial proceed.
But Lordship will arrest him, Your Lordships.
You will not arrest it. 3 years you have not arrested.
But
as a result of which the trial is not proceeding.
Trial is
and it is a burden on the system.
Your Lordship, trial is proceeding for the other accused. He is coming and filing, Your Lordship. He wasted Your Lordship.
Mr. Rai, try to be practical. If he is voluntarily coming, and let him come and participate in the proceeding. I am not giving him bail. I am only saying that he will appear and resort to the remedy available to him under law.
Lordship may kindly ask him to annex the petition, then Your Lordship may hear it.
Yes, Mr. Mahapatra, annex it Friday.
Yes. I'm annexing that petition, and I pray Your Lordship to ask the CBI.
I am not going to protect you in any case. I will only give a date that you on that day you go and appear before and surrender before the court.
My challenge is, my lord, one thing. Let me clarify just 1 second. My lord, only my challenge in the original criminal miss case is whether non-bailable warrant can be issued when I was not shown.
Forget about all the technicality. Then
only challenge. And
then we'll hear it, Your Lordships.
He time and
Lordship-
again making
Lordship,
assumption that I was shown
Your
absconder.
Lordships.
Let him file a single piece of
Oh, forget
document that
about
I was
that.
absconder.
Your Lordship, let him file.
You get
Then
ready
he
to
misleading the
you
court.
get ready to appear before or surrender before the court on a
Yes,
particular
Your
date,
Your Lordship.
Yes,
and you move application whatever you want to do.
yes, Your Lordship.
But
That
he
much
not be
I want.
protected. But he not be
No
protected.
question. No, where is question of protection?
So
I'm
let
not
him fi-
protecting.
Lordship, let him file it, then we'll take up, Lordship may take up
Yes,
the matter.
I'm not protecting. I'll only say that on or before on such and such day he will appear before the court. That's
Yes.
all. And resort to the remedy available to him under law.
Yes, Your Lordship.
That is
Then
what
you
I
are
want.
he is also his petition is allowed partly, and you also
Yes,
succeed.
yes, Your Lordships. Let him annex the petition and.
I'll pass that order. Why are you unnecessary? I'll restore it and pass that order and finish it up.
Yes, Your Lordships.
Okay.
Yes.
But they do. Yes.
One thing that
And otherwise, what will happen, Mr. Naik? Your officers will keep on searching him. He will never be, available. Till now, your officers are unsuccessful apprehending him.
Order issuing NBW may be set aside.
No.
And I will be appearing.
You go and appear. Yes, I'll pass.
Yes, I will appear.
Yes. Yes.
Your Lordship, a free copy of the order may be
Prayer
provided.
for,
Yes. Yes.
Hello, prayer for modification is only to the extent that the name of the respondent number 1 may kindly be read as Bapina Naik instead of Bipinu Naik. In the
What Naik?
instead of Bipinu Naik, it will be read as Bapina Naik because the name Bapina Naik appears in the impugned judgment, but inadvertently the
No. You have caused rightly just see. Bipina Naik you have written.
that is their mistake because the impugned judgment.
No, then in the petition you have to seek amendment. Not the order. Order is correct.
No, order is correct, but the appeal memo itself is wrongly filed.
So then you correct in the appeal.
I am the respondent number 1.
You correct the appeal.
Yes. Impugned, in the impugned judgment which is challenged. Bapin only.
But in the appeal memo you have to correct it, sir.
He will correct.
You correct the appeal memo.
He will correct me.
The
Because stamp reporter could not point it out.
This modification application is filed by the respondent as the name of the respondent is wrongly written. Written as Bapina.
Bapina. Instead of Bapina.
Bapina, na? Bapina or Bapina?
Bapina. B-A-P-I-N-A.
B-A-P-I-N. Bapina. Let us see impugn order.
Wrongly.
Bipina. B-I-P-I-N-A. Okay.
Wrongly he
But, it should be B-A-P-I-N.
Let my learn.
1 minute. And in the appeal memo, inadvertently, the name of the respondent is also written as Bipina Naik. Bipina Naik. That's the correct reason. In the order dated 14/2/2025, the error which occurred. The counsel for the appellant submits that he would correct the memorandum of correct the name of the respondent in the memorandum of appeal. Once the name of the respondent number 1 is corrected in the memorandum of appeal, the order dated 14/2/2025 shall also be the correction in the order dated 14/2/2025 shall also be carried out. The counsel for the appellant is allowed to correct the memorandum of appeal within 2 days, and thereafter the order dated 14/2/2025 shall also be corrected accordingly. To this.
He may be granted liberty to correct.
Yes,
in the office.
That I have given. Yes.
64.
Well, in this case, one IA bearing number 92/25 filed showing deposit of awarded amount and stay that is not in the board. So let it taken on Thursday, my lord, along with this IA application.
Which I?
My lord?
Which I? Have you filed some?
64, my lord.
Where is that I? It's not there.
No, not there, not in the board, my lord. Let
counsel for the
IA number 92/25.
Service that he has filed an IA.
92/25 on 6th February.
Which is not on record. Raise the directed to place it on record. Please the matter after next week. Take. Yes.
66.
Good item 66 में काहे pass over माइंड pass over.
68.
We have placed Vokalafalama on behalf of the opposite party, taking consent from previous lab.
Okay. Then counsel also has submitted that he has taken consent from the previous counsel who was appearing for opposite party.
Yes.
Opposite party. He can able to file the power of attorney, lease the matter. Yes. Yes.
69.
May I please, madam? The petitioner has this application for unfreeze the bank account, madam. The bank account has been freezed by the on letter of a police, and the bank freeze the account and not operate, madam.
Yes.
The accused, initially accused as a
Notice.
notice is not sufficient. Is
Not sufficient. Notice on respondent number 3, the opposite party number 3 is not sufficient. And then counsel of the petitioner to take fresh steps for service on the respondent. Yes. Yes.
70.
My lord, in page number 2 of the petition, my lord, paragraph number 1, in line 3 of the petition, my lord, the case number of the lower court has been wrongly typed as special case number 31 of 142 of 2018, my lord, instead of ST case number 31 of 142 of 2022.
Therefore, the
Yes, he could not avail your lordship's order.
it should have been 22.
My lord, ST number 31 of 142 of 2022 हवा कथा किंतु है ये चीज special case number 31 of 42 of 2018.
Okay, inadvertently in the para 1 of the petition, the PS case number has been
Special
wrongly typed as Rusuri PS case number 83 of 2018.
My lord, PS case number is correct.
Which one then?
My lord, the para 3 of the paragraph, my lord, special case number.
Para 3.
My lord. In line 3, sorry. Line 3, paragraph 1, line 3.
Special case number.
Special case number
31/142.
2018.
2018.
That has been wrong.
In place of 2022.
That is the wrong case. The correct case number is ST case number 31 of 142 of 2022.
22. That's the reason in the order dated 22/11/2024, the error has occurred, and he seeks liberty leave of this court to correct the para number 1 of his petition, and accordingly once correction is made, same shall be granted.
Extend the surrender. Extend the surrender time.
Gotcha. Extend judge of the state confusion. The petitioner could not surrender before the court as directed by the by this court by the order dated 22/11/2024, and seeks an extension. Accordingly, extended. Yes. Yes.
91.
May
Yes.
I please?
Yes, sir.
This is my petition for quashing, my lord.
Yes, notice was issued to who is appearing? Who is appearing, Mr. Maharana? Nobody is there for vigilance.
Last time.
Yeah, call them. Yes, what is this case, by the way?
Yes, no. Lord, this is a matter. I'll just give a very brief background, my lords, and then I'll go into the specifics. The allegation is, my lords, there was originally a lease, my lords, by my father in 1959, a mining lease.
Yes.
That was for a larger area of 260 hectares. For two things, it was manganese and iron ore. Manganese admittedly was given up somewhere after 15-20 years. That's not in dispute. The lease for iron ore, my lords, was for 30 years and it was to expire in 1989. Now, what is important, my lords, the mining lease was originally in my father's name and there was a partnership firm from 1974 which was essentially operating the lease, the mine. On 30th of July 1988, an application for renewal is made.
When was it supposed to expire?
It was supposed to expire, my lords, in the normal course on 30th July 89.
Your application for renewal?
Is 30th July 88.
1 year before.
Yes.
That's the standard year.
Yes.
Hmm.
Now, my lords, while that remained pending,
Yes.
they were in the interim, my lords, certain by 6-month periods, we were given permissions, my lord, to work the mines in 6 months period. Also, my lords, at that stage, they were also, I will show, my lord, there was a recommendation from the authorities to the state government that the lease be renewed. Now, meanwhile, my lords, 2-3 very important things happen. One is because my father by then was aging, my lord. He gave her a power of attorney in favor of my elder brother and me to operate this. Secondly, subsequently, the partnership firm was reconstituted. He exits the partnership and me and my other 4 brothers, so 5 people, my lords, become partners of this reconstituted firm. That is one part. Now, the other date to note is, my lord, on 5th November 1995, my father passes away. Mr. B.D. Patnaik passed away. My lords, there is correspondence between me and the department, me and the minister for forest clearance, etc. And my lord, ultimately, because nothing fructifies, we surrender the lease, my lords, on 31st July 2009. Prior to this, my brother, my lord, elder brother, Mr. R.N. Patnaik, also executed a power of attorney in favor of his son because by then he was also getting on in years. The allegation against me now is that there is illegal mining, my lords, from 1989 to 2009.
Till you surrender.
Yes. And the allegation is against 13 or 14 government officers on the allegation that they have assisted me or conspired with me to further this illegal mining.
What happened to common cause consequence?
Common cause, what happens? I'm grateful. Pursuant to common cause, there is an adjudication of penalty of 8 odd crores. And most importantly, that is paid by the firm. So what has happened in this case is very curious. The charge sheet, because subsequently charge sheet is filed, etc. The charge sheet keeps referring, my lords, in several places to ML holder, that is mining lease holder, ML holder, ML holder. But at 2 or 3 places shifts the onus completely on me and say that because you wrote some letter, you are the one who has conducted the illegal mining. Now, my lords, fundamental, my lords, concept in criminal law, if there was, my lords, because under the MMDR Act, my lord, Section 23 imposes a liability on officers, etc., etc.
Yeah.
Admittedly, the firm is not made because Mr. B.D. Patnaik is gone. The firm, my lords, is not made an accused. I have shown, my lords.
But all the partners are made accused.
No, I am the only one. Firm is not an accused. My 4 partners are not accused. I am the chosen son, my lords, who has been given this, what should I say, privilege.
Where is, yes, Mr. Marana. Let him come, we'll see.
After lunch?
Let him come. So that's the case. See,
yes, and of course, there are some issues of authorized. So I made 2 or 3 broad points I can indicate. Yes. One is this, that you have not, there is some political background, etc.
Common cause consequences have been suffered by the firm.
It says, may have signed the letter. It says for B.D. Patnaik, so-and-so partner. It is not my individual personal liability. It is the firm's liability. Sales tax returns filed by firm, income tax returns filed by firm, royalty paid by firm.
Happy if your brothers comes in.
I don't want to convert this into a 319 proceeding.
That precisely is the grievance. Why the other brother is left out and I am being...
No. I'm saying this shows, Lord, in terms of Bhajan Lal, how this is vengeance.
No,
This is
when
motivated.
because see, perhaps I don't know. I have to see it.
Yes, my lord.
Perhaps you are the only person who must be operating. Maybe the other brothers,
No.
maybe silent partners.
No. No, I'll show that. That's not the case.
And you said that you have written mails and all.
And not in the
Correspondence-
partnership deed, they're all 20% holder shareholders of profit.
Maybe, but what happens is it's not a case of vicarious liability. It
I am
can't be a
saying-
case of vicarious.
I am saying, my lord, I can understand if I am the mining leaseholder. There I have no argument to make. Lease is in my name. Whatever I have done,
It
I
is
must
the name
suffer.
of firm.
It is the
Of
name
a father.
but the reconstituted deed says that the firm is continuing the business.
Let us see.
Yes,
Let
ma'am.
him come.
I'm grateful.
Between you and your husband, both of you are lawyers. He is trying to do something. He's a senior person, and respect him, and he may do something good for both of you. That is the reason I am saying.
I'm respecting, sir, but yesterday he visited my home. Before that, he visited 3 times with Sritam. Yesterday, he directly said to me that he is not going to interfere in my case anymore. For that, I came to mention today, sir, please cooperate in person with me because after hearing any order may pass, Your Honor.
And you don't want to settle if you keep on fighting like this.
No.
There is no end to it, you know. If a senior counsel is appointed by this court, he is trying to help you people. Try and listen to, see.
He tried, Your Honor.
I called you twice in my chamber, both of you.
Your Honor, he tried.
I have spent nothing less than 2-3 hours to make you people understand. Why are you fighting like this? Just see the child.
I don't want to fight. I want to.
You don't want to fight, you
yes.
don't want to listen to the court, you don't want to listen to the senior counsel appointed by the court. What is this?
Your Honor, he is.
You have to listen to someone in the life. Then only things will, you know, be settled. Anyway, it is your wish. I can't help it. Okay, lease it. We'll see. We'll not waste time. Yes. Yes, sir.
The Brother remember me that CRLA 25, that vigilance case when I prayed for suspension, when your lordship told me and finally hear the matter.
Yes.
And last time.
You are seeking stay of conviction. I said that we'll hear the appeal, sir. Yes.
That was unfortunately Mr. Das, that took time. Then
I don't think he's there.
Appeal, Mr. Das. So any day your lordship likes.
Sir, let it be there in the board itself.
It is not there in.
It's there. It was fixed to 20, including the list. Weekly list. I'll include it. Yes, sir. I will include. Yes.
Oh, bless.
Yes. Compromise. Which one?
72.
72. Yes.
Please, your lordship.
Yes.
When the petitioner has made a prayer for a quashing of the criminal proceeding on the ground of compromise, the other day it was there. Now the victim, informant, they have appeared through lawyer and filed prepared.
No, what is the stage of investigation?
Only affair is just lying.
What is the age of the girl?
19.
19. Now 19.
She is also present.
How?
What is the terms of settlement? They are married now.
They're married. They're
The accused has married. Huh? Accused. Who are the accused here?
D'accord.
T2 Sau.
T2 sound the.
Mrs. Marana, ask the girl whether she's satisfied marrying. Yeah. Instance of opposite party number 2, FIR number 4, yesterday was the petitioner. The investigation, allegation the investigation in the present case is still going on. At this stage, the parties have settled their issue. Petitioner and the victim petitioner accused and the victim are present in the court in person, represented by the respective counsel. We have the petitioner and opposite party number 2. Nine. Petitioner and who is the informant?
Elder father of the victim.
Where is he?
He's
there.
Giridhari Sahu.
The informant, the elder father of the victim, has filed an affidavit, and the victim, who is stated to be 19 years of age, has also filed a separate affidavit dated both dated so they have inter alia stated in their application in the affidavit as under para 2286.
For place of the occurrence is 30 kilometers, Lordship. You know, the Learned Honorable Appeals Court has clearly hold that it is not at all practicable to attain in the
on the fact of that case.
Yes, Your Lordship. But here is the case PW 1 and 2 has stated the name of the present petitioners in the alleged involvement in the crime, Your Lordship. I am relying the deposition, Your Lordship, PW 1, Your Lordship.
Yes.
Page 29, Your Lordship.
29?
Yes, Your Lordship.
Yes.
Here is the present person Abhijit Bastia and another is Your Lordship. Jagat Jivan Bastia, Lordship. The present petitioners, Your Lordship, these are. But here the PW 1 has clearly stated. May I read, Your Lordship?
Yes.
Occurrence took place on 10/12/2023 at about 11:30 AM on the public road in front of my house. A marriage function was organized in the family of Hon'Ble, and I attended that marriage. At that time, accused Biswajit Bastia, Abhijit
Bastia is the petitioner and Jagjit
Bastia were passing through the spot on motorcycle. Their fellowship. My son Sushanta was standing on the side of the road. They stopped near my son. They stopped near my son and stated by using that caste, Your Lordship, Kandra and
in the PW2 31 also same.
Yes, Your Lordship. That is the consistent deposition deposed by the PW 1 and 2, Your Lordship.
And
accordingly,
34 also.
Yes. That, you know, the prosecution filed this petition and accordingly the lighter. There is no discrepancy, Your Lordship, in the deposition.
I'll come to the discrepancy, my lord. The judgment that I am referring to, the similar situation, my lord. The informant in that case, also the family members of the informant, they consistently stated in the 161 as well as in the deposition that the respondent number 2 therein was involved in the crime. That was also the submission of the learned counsel for them that, that he has been named in the FR. Despite that, the Honorable Supreme Court referred to the 161 statements of the persons who were working with the respondent number 2 therein with the respondent in the.
Where is the 161 statement of these witnesses?
161 statements
of these same witnesses.
Of the same witness. Page number 4 starts from 49.
49. Yes.
Madam. In the 161 statement, they do not say anything about the disrobing of his wife, anything, nothing. Improvisation in the deposition, my lord. In the 161, is the same story that the 3 of them came in a bike and.
No.
That is
come to 49, page 49.
Page 49, they have stated. Sushant Kumar Malli.
Abhijit Bastia o Jagdish Bastia, ସମସ୍ତଙ୍କ ପିତା Saroj Kumar Bastia ସେ ବାଟ ଦେଇ ଯାଉଥିଲେ ହଠାତ୍ ମୋତେ ଦେଖି ପୂର୍ବ his name is there.
My lord, my point is in
161 statement
not this, my lord. In the case that of the Honorable Supreme Court, in that case
talk about this case first.
In this case, my lord, none of the independent witnesses. It is a case under SCST Act,
those things are not. See, you have said that the same set of witnesses in 161 statement had not taken the name of the petitioners, as a result of which charge sheet was not filed against them.
No,
but when they step into witness box, these people have taken up my name. So therefore 319 is invoked.
My lord.
That is your case.
My lord.
So I was examining whether
No, no,
161
in 161, they have stated. My
Yeah.
case is that the independent witnesses, my lord.
Oh, these things.
My lord, that is what I am avoiding the.
I'll write the order.
My lord,
Give it.
My lord, may consider, my lord, at least consider my submissions, my lord.
Yes, yes, I'll take that.
My lord, the case that was before the Honorable Supreme Court, the Honorable Supreme Court went into the statements.
Is that the test today? 393
My lord, the
witnesses
case
have
of-
categorically taken your name.
The test for 319 is not that is at the stage of framing of charge. In this case, merely stating the name of
Evidence
the.
has come. How will I deal with these two
But
things?
there's discrepancies in the evidence, my lord.
Can I go into discrepancy at this stage?
Yes, my lord.
So we any judgment?
Yes, my lord. This judgment, my lord.
319 state.
This
I'll
judgment,
see
my lord.
discrepancy.
My lord, in this judgment, the Honorable Supreme Court has referred to Hardeep Singh, and it has stated that it is not the one that is
So, see, I'll deal that.
Here is the case, the judgment, my lord, and is relying is the different facts of case or lordship. Here on the.
Which paragraph? 1 minute. Which paragraph?
paragraph 10 of the
What
judgment.
is the ratio decision? So,
The paragraph 10 of the judgment, they had a reference to Hardeep Singh that 100 and
what is the ratio?
paragraph. Thus, we hold that though only a prima facie case is to establish from the evidence laid before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but sort of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. Sort of satisfaction, my lord. In the absence of such satisfaction, the court should refrain from
Yes,
exercising.
I've seen. Now, so with impugn order. Impugn order.
Impugn order is at my lord, page number 24. Starts from
20?
24.
Yes. Yes. Yes.
Operative portion is page number 27, last paragraph. PWs 1 and 2 have also deposed that all the three accused persons assaulted PW3, abused them aspersing their cash. So I am satisfied that the evidence adduced on behalf of the prosecution, if unrebutted, may lead to conviction of Abhijit Basti and Jagatjit Basti, and they are sought to be added as accused person. But this is not the satisfaction that has been canvassed by the Honorable Supreme Court, my lord. It says that it shall be sort of the satisfaction that if it goes
Up to page 27.
My lord.
Last para 9.
My lord.
Read it.
I peruse the evidence adduced by the prosecution in this case. PW3 is the person who was initially assaulted and abused by the accused persons. His evidence reveals that Biswajit, Abhijit, and Jagatjit Basti abused him as the caste allegations, my lord. And when he protested, Biswajit inflicted 2 fist blows, and other 2 accused persons laid him on the ground and inflicted fist and kick blows at his chest and belly. PW4, who is the wife of PW3, has also deposed the same facts. He has further deposed that.
Yes.
My lord. My lord, this is the allegation.
And next, PW1 and 2.
PWs 1 and 2 have also deposed that all the 3 accused persons assaulted PW3.
How after this finding,
well,
how this?
But this is not a finding. This is the submission that was.
Yes,
that
is
is the testimony that came during
what
trial.
the evidence is.
My lord. After that, my lord, this is where I am taking the support of this Supreme Court judgment. In this case, my lord, the informant, along with the family members of the informant, had consistently stated in 161 as well as in the testimony that the accused therein was involved in the can, and also alleged overtake. The Supreme Court has recorded that. After that, the court went at paragraph 12, my lord, the appreciation of the court. The court went into the statements of those persons who are working with the accused. In their statements, they stated that we have the accused was with them. In my case also, there are independent witnesses. The allegation is that there was a marriage function, 50 to 60% of general caste were there and 15 to 20% of their own caste were there. It's a crime under SC/ST Act. And unless those caste aspersions and allegations are made in front of a public, that those allegations itself will not be hold, my lord. And PW1 has stated that PW1 2 stated that there were persons. My lord may come to cross-examination of PW1. He stated that such and such persons were there.
But in this case, which you are citing, that there is a plea of alibi. The court says that see, the investigating officer has well verified the fact that he was not present and all these things.
From the
not a case of plea of alibi.
Well, from the statements of the persons who are working with in this case, my lord, in this case, it is stated that it is at a public place. None of the independent witnesses, in fact, the independent witnesses have stated that.
Try to distinguish the facts. What the fact of the case which you are citing is, in that case, the closure report was filed.
My lord.
Police investigated and found that the gentleman who was posted somewhere in a Bridge Corporation somewhere in Lucknow, he went and verified. He was on that day, he was there. On that basis, a closure report was filed. And protest petition and the witnesses orally have said that no, he was there. So the court says that the investigating officer has verified his presence somewhere in the Lucknow. Today on the oral evidence, I can't summon. That is the case.
In this case also,
How can you match the facts?
In this case, there was no paper proof that he was there. It was on the basis of the statements of the colleagues, my lord.
Anyway,
in this case, in this case, there are independent witnesses who are stated by the informant itself that he or she was standing there, and they said independent witnesses have stated that only Biswajit Bastia came, assaulted the person.
Where is the evidence of independent witnesses? They have not yet been examined.
But they have been examined, my lord.
Where is that evidence? Show me.
PW5, my lord.
Where is that? Page?
PW5, there he's hostile, my lord. PW coming.
Yes.
Page 42, my lord.
The victim himself says that this has happened.
PW3. Victim himself says that.
Yes. Then
there is, my lord, there is discrepancy in PW1, PW4 to the extent PW4.
I am not right. I am not pass an order judgment on acquittal.
No, ma'am.
I can't appreciate the evidence at this stage. I have to appreciate.
I'm only trying.
Some evidence has come against you. Therefore, 319 is invoked and you have been submitted. Three witnesses have.
The question remains.
And you want that I should see these three witnesses in the light of the evidence of other witnesses. That is not permissible.
Well, at the stage when witnesses have been examined, the court can go into it, my lord. Because the discrepancies are there.
That is not the judgment. And the judgment is something different.
Discrepancy.
You well tried. You have tried. If you want one more opportunity, I'll give, because you are arguing very well. I'll give you one more opportunity. Tomorrow you come with some judgment.
All right.
Okay.
Man.
Let it be tomorrow. Huh? I'll list it tomorrow.
Man.
You come, if you can get some judgment, then I may help.
Man.
Okay.
Man.
You are trying hard, therefore I'm giving you opportunity. But you don't have a case. Yes.
Thank you.
Let it be tomorrow. Yes.
I'm grateful.
20.
Here is a case arising out of a complaint case for quashing of order of taking cognizance. But here is a case to not to inquiry document nahi, your lordship. The documents are not with me, but here is a case 420-406, your lordship. First over.
None appeared even in the second call. For the petitioner, in the interest of justice, said them to make. Yes.
21.
Yes. Same. Complaint case?
Here 21 brief is not with me, your lordship. That is CNR is not with me.
What is he asking? Yes. None appears in the second call. In the interest of justice, said them. May Rakna. May. Yes.
56.
See, these revision petition, the review petitions are pending since 2009. What to do? Review petition, na? Right of this review petition is pending since 2009. To this, and since 13/17/2009, the following order was passed. It's called defect, as pointed out by SR within a week. Defect within a week.
Sorry.
Yeah.
56. Sorry. Violation review not correspondence as a norm.
There is no step taken by the petitioner as yet, pursuant to the order dated 17/4/2009. Even in the second call, none appeared for the petitioner, and you thereof the petition is dismissed. Yes.
57.
57 also the call. But this matter is pending since 10/6/2000. The review petition is pending since 10/6/2009. 9, and the SR has pointed out structural defects. The same has not yet been cured. Even on the second call, none is here for the petitioner, as the petition is dismissed, yes.
66.
Yes.
May please, Lord.
Yes.
And for the petition, my lord. The matter has been, my lord, amicably settled, and we have already filed and joint compromise affidavit by the victim and the informant, my lord. My learned engineer is appearing on behalf of the victim and the informant.
Kindly, flag A, your lordship, kindly, since that was before your lordship last in call for, that is your lordship's brief flag A, your lordship.
Flag A?
Yes, sir.
Yes.
That was before last your lordship.
Yeah, what is the terms of settlement?
Lord, here, kindly see agreement, lord. Annexure 2, page number 17 of 164 statement of the victim, my lord.
Yes.
He has not admitted, he has already now in our in-laws house, my lord, before the accused person, my lord. And now he's residing, my lord, there is a compromise and the also the informant.
But it's all right, but see, 16 years.
And now he's now
maybe
25
16
years, my lord.
But the informant, lordship.
Now it's 16 years. POXO is there. That's the problem.
POXO is there, my
Huh? See, 16 years.
Four POXO is there. The
The
76.
mat-
And 4 with post-court, you know, the application.
Yes, Mr. Nats. Yes.
But in the brief question, one indication, of course, I had given that is just one of the points. The second, my lord, is that just kindly note, my lords, 2-3 dates.
Mr. Maharana, ready?
Tell the instruction. Not obtain the instruction.
See, the first point which what he has argued is the license stands in the name of his father. Father expired and a partnership form is constituted. And the common cause consequence is suffered by the firm. Now, by singling out one of the brother out of 4 brothers, 5 brothers,
Now 4, because
and the petitioner is being prosecuted. So he says if the farm have suffered the consequence of a common cause, and it is the father who was having the license, and through the firm the business is being carried out subsequently. Why singling out one of the partners, leaving others? That is the whole long result
Apart
of.
from singling out in law, you cannot. And the most recent judgment of the Supreme Court, where what happened, my lord, for some forest violation, they had impleaded only, or they had accused only the 3 directors. The company was not arraigned. Supreme Court quashed it.
No, the company is in a different pedestrian altogether.
Person is, under the act, person includes firm. So I'm equating that, I'm applying that logic to partnership, because the person under 23 and under the MMDR includes a company, firm, etc.
Firms
etc.
and
So that same logic will apply to that. That's what I mean.
This is the
That is one
this
point.
is one point.
That point is there. To that extent, it has been extensively argued, and this honorable court was not entertained, inclined, and matter went to the Supreme Court. Honorable Supreme Court has also dismissed the petition, giving only point to argue during trial. That is on the point whether the person who was investigating the matter was competent or not.
No.
And so far as those contentions are concerned, all are factual. It can be well adjudicated whether why it was there. And another aspect is that record shows this person was managing everything. And power of attorney, he was the power of attorney holder.
So that's what I was asking him. If you are managing everything,
Once
then
it has been
correct me.
adjudicated, the matter has been adjudicated here after thorough hearing.
Can we go? Can
Let it come some other day. Because
You tell because he is not well, that's what he was telling.
If he's not well, I can't say.
So then you tell me
The
when.
only thing I want to clarify, of course,
Yes,
you're not
yes.
fixing another date, that's fine. Only thing I want to clarify, this point was not taken in the first round. I will show in my turn. There was a point on authorization and whether the officer had the requisite authority under the notification. But that point was urged at the discharge stage. That point, Supreme Court says, I leave it open. That's the first thing.
To urge before the trial
It
court.
doesn't say trial, it says I leave it open. The order of the
Leave it open to, obviously, leave it open means to be
it
argued.
clarified that contentions raised by the petitioner with regard to the competence of the officer lodging complaint is kept open. That's all it says. That is one. Secondly, my lord, that was a discharge. We are at 482. The lordship is aware,
Yes.
but the scope is different.
Now, what is the stage now?
Now I am at 480. No, in the trial.
Right. Yes.
In the trial, my lords, I'm told, my lords, even charge has not been framed.
And
That's what my
the matter
instruction
is lingering since 2009 at the behest of the petition.
Let us,
Yes, but the petition-
what I'll do is, I'll simply adjourn and ask for.
It's a very interesting submission made. Lingering since 2009 at my behest. You have filed the charge sheet only in 2013. What is my behest?
It is lingering.
2013.
Charge sheet also.
2013 only.
Charge sheet also, it was filed.
Another accused.
Let me get the report from the trial court.
Yes.
In the meantime, and I'll fix a date. You tell me when. Where is that court? Which court is trying? Which court is trying?
Vigilance court, but in the meantime.
Special court.
Perhaps it has been transferred.
Which court is it?
It has been transferred to
Additional district and session judge Burger.
Burger, huh? Is directed to furnish a status report regarding the progress of the trial. In so yes. Is the matter for further hearing. I'll treat it as a parted further hearing on such and such day. You tell me the date.
Will April 10th be convenient? 10th or 11th, whatever.
10th April, okay.
10th, yes. That week I have
Okay.
It's on 17th.
17th? 17th?
Very well.
17th, okay, 17th. Yes, next.
Great.
Yes, next.
73.
Item 76 is the Benson matter. I was filed for the extension of surrender.
Extension of surrender. For the have you moved an application?
No, sir, I was filed.
Oh, sure. For the reason stated in the application, the same is allowed. Time is extended up till 30th. Sir, 30th. Yes.
74 also same man.
74 also same.
Extension of.
Extension. Yes.
That too.
No further extension shall be given. Yes.
75.
My lord, in your case of civil dispute between the parties, their father, forefathers, grandfather, they exchange their property. We are not aware about this. Lordship may see, petition number 1 is a forest officer, 2 is the doctor at Capital Hospital, and the others are, most of the jails persons are the government employees. In this case,
what are the allegations?
420 Jagas, Lordship may see that. Annexure 1, Lordship may see, then that GR case 160, that has been closed by the police. None of that previous case. This.
And let us see the allegation.
Protest petition was filed. Then the Lordship may turn to Annexure 3. Same self-issue, civil suit is pending. And we are the, my lord, the respondent. Lordship may see. Dependent. Page 17.
No, what have you promised to sell the property?
Grandfather कौन करथिले आमे केमति करू से आम प्रॉपर्टी सी नै गेले टाकाटा आमे नी से तो टाका बिना दैट वाज द रेकॉर्डिंग द
सेटिंग करना
नोटिस करके ए जदी हां नथिंग एल्स आम इन्वॉल्वमेंट नहीं
and issue notice
honorable appeals court judgment
yes forget on fact is government issue notice to opposite party number 2 let the opposite party number 2 see he is also 70 years.
Yes.
We served through the IIC of so and so IIC through IIC Sobkoro. Release the matter on next week.
Notice.
Next week.
My lord.
So through IIC service.
Through IAC.
Through IAC as well as through, you file the process and give additional copy. So that through IAC, it will be easier next week to do it.
My lord. Okay.
We'll finish it up.
IA টা কিছু flyover. IA is
Let it be, let the IA be there. If
Hon'Ble.
next time he comes and do, then I'll stay.
Yes.
IA for dispensing the certificate copy, that I'll allow. There is no IA for stay. If next time you come and file that up.
My lord.
Okay. Yes.
76.
I am seeking permission of your lordship. There are typographical error. Instead of SDGM Anugur, it has been written JMFC Anugur. And it is
SDGM होगा कथा ना?
SDGM होगा कथा.
13/2/2025 रे SDM होगा.
Body रे भी करियो पड़ी. Body
हाँ ये तेरे सेम लिख दो. Mr. Sujata General and counsel for the petitioners submits that inadvertently in place of SDJM Anugur, JMFC Anugur has been mentioned in the petition. Consequence thereto, the error has occurred in a page in order dated 13/2/2025. He seeks the leave of this court to correct the errors occurred in the petition. The same shall be done within 2 days. Subsequent thereto, the correction in order dated 13/2/2025 shall also be taken.
petition as well as prayer also.
And the
Is
prayer,
also-
entire petition prayer, allowed.
77.
May I please?
তাহলে স্যার ইনস্ট্রাকশন নাম এদের সব পাই ডকুমেন্ট মাগিছিলে আপনারা
Panch Tarik, sir?
No, no, I'm after 6, I will be absent, Malad.
You tell me.
You want on 5th?
7?
No, 7, 6, 7, I'll be absent. Let it come on 5th, well, or next week anytime.
Next week or this? Next week. Next week कौन से week? Next week कौन? 10.
Malad.
10, okay. 10. Yes.
78.
That matter, my lord, that your lordship was asked for a report from the concerned SP. Then, my lord, report was received, but it was a lengthy report. For that reason, the State Council was asked for some time to go through the report and then.
Yes.
Hey,
Have you gone through the report, Mr.?
Yes, sir. We have gone through the report. That report, some discrepancies are there. Paragraph 4 and paragraph.
What can I do? You are SP has given the report.
Okay.
You find out discrepancy there also.
And may I draw your kindness? In affidavit, they have filed in October 2024, they have filed an affidavit filed by the complainant and complainant's wife.
They are also
And
present before this.
further again, they have filed another affidavit. And the statement made by the informant, all are different.
No, that affidavit was filed before the Warrant court below. Then we have filed the affidavit and that informant and victim, they are the.
What are the offenses?
Offenses 3 of the SC/ST Act, my lord. And they are present also. Matter has already been settled. My friend is appearing for the informant.
I think you are a police inspector.
Yes, my lord. Yes, my lord.
That's matter.
Therefore, I was whether you have really they have given it in the free will or.
ସେଥିପାଇଁ ଆଜ୍ଞା SP ଙ୍କ direction ହେଇଥିଲା ଯେ supervision.
Show me that report.
ଆଜ୍ଞା ସେ report ଦେବେ.
Show me that report. How many cases are there against you?
ଆଜ୍ଞା ମୋ ନାଁରେ ଏଇଟା ଗୋଟେ କେସ୍ ଆଉ ମୁଁ ଯେତେବେଳେ ଆଜ୍ଞା ଥିଲି କଟକରେ ସେତେବେଳେ ଟ୍ରେନକୁ ଅଟକେଇକି କିଛି ପିଲାମାନେ କଣ କରୁଥିଲେ ନା ପଇସା କଲେକ୍ସନ କରୁଥିଲେ ସିପିଏମ୍ ପିଲା ଯୋଉ ଡବା ଧରିକି ଯୋଉ ପଇସା ସବୁ କଲେକ୍ସନ କରୁଥିଲେ ସେତେବେଳକୁ ଯେତେବେଳେ ଜାମ୍ ହେଇଗଲା ଟ୍ରାଫିକ ଜାମ୍ ହେଇଗଲା ସେମାନେ ଇଏ ନ କଲେ ମୁଁ ସେମାନଙ୍କୁ ଏଗନେଷ୍ଟରେ ଗୋଟେ କେସ୍ ଗୋଟେ ରେଜିଷ୍ଟ୍ରି କରିଥିଲି ଆଉ ସେଇଥିପାଇଁ ସେମାନଙ୍କର ଆଲିଗେସନ ହେଲା କାହିଁକି ଆମେ ସବୁ ଶିକ୍ଷିତ ପିଲା କାହିଁକି ତମେ ଆଣିକି ଆମକୁ ଥାନାରେ ବସେଇଦେଲ
I don't know, wherever you go, you create.
ନାଇଁ ଆଜ୍ଞା ଯାହା ହେଲେ ବି ଆଜ୍ଞା ଚାକିରି କଲା ମାନେ ଯାହାର ଟିକେ ମାନେ ଇଣ୍ଟରେଷ୍ଟ ଆମର ହବ ସିଏ କଣ କରିବ ନା କେସ୍ ବର୍ତ୍ତମାନ ମୁଁ ପ୍ରମୋଟେଡ୍ ହେଇକି ବର୍ତ୍ତମାନ
Lengthy report. This is.
ଆଜ୍ଞା
Yes, just show me which part is you want.
Your lordship kindly, paragraph 4. A red mark.
Yes.
Paragraph 4.
Thereafter 7.
No.
A hot exchange of words between the petitioner and the
Who is Munna?
Munna alias that
He's the
Manoranjan
informant. Informant. He's the informant.
ଅଛନ୍ତି ଆଜ୍ଞା।
The para 9 and 10 is important. Yes. Para 9 and 10. Write down. Where is the accused?
Hello.
Accused.
My lord, that ସେ ସବୁଦିନ ଆସନ୍ତି ମାନେ he had come regulate, but today, my lord, due to some law and order situation, he could not appear today, my lord.
Then he should come.
Well, that is the problem.
Show me tomorrow, day after tomorrow.
Day after tomorrow.
Day
Yes, I will intimate.
9 and 10 paragraph just see. That will help you
Aye.
in the report.
Aye.
You will not read it, it seems. Para 9 and 10.
ତାଙ୍କ report ଆମ ପାଖରେ
Just see, give a copy. This is not classified document. Give a copy, but yes.
Aye.
Yes. Para 9 and 10 will help you.
Aye.
That's what I read.
Because copy was called for and report is available with
Yes.
them.
And he was beaten up by he was taken to the police hospital with the Manoranjan Dhalai.
Aye.
The report says that he is a Gunda kind of person and he for no reason he has gone to the police station and insisted that the Alok Behra should be released.
Aye.
Allegation is the IIC has beaten him up.
Aye.
He was admitted to the hospital. When he was in the hospital, during that time, he has never said that IIC has beaten him up.
Aye.
Subsequently, turn up and file a complaint. That is what is the reporting.
Yes, ma'am.
You have not read that. Read.
And the report is.
Everybody will come.
Aye.
Everybody will come.
Obliged.
Yes.
I'm for the OP number 2 in first case.
Which one?
ନାଇଁ ସେଟା ଆପଣ ଅଲଗା କରିଦିଅନ୍ତୁ ଏଇଟା ଆମର ଏଇଟା ଥାଉ ଆଜ୍ଞା ଏଇଟା ଆମର ଆଜ୍ଞା ଡେ ଆଫ୍ଟର ଟୁମରୋ ରହୁ
ବୁଝି both the matter let it come.
ଆଜ୍ଞା
Yes.
ନାଇଁ ଡେ ଆଫ୍ଟର ଟୁମରୋ
Yes.
79.
7th पे लगे आपको 7th को 7th yes. Yes.
79.
Assisi instruction.
My lord,
Yes, Mr. Vishal.
may I please, your lordship. This is a case, your lordship.
Your lordship called for the LCR. And the noting shows that the LCR has not yet come.
Asini.
Naya. LCR has not.
Asini. Pursuant to the which order is that? Why registry was directed to that? Why it is not done?
Because of the shifting of the courts, probably the records are not traceable.
Okay.
Your Lordship may grant some.
Not that it was closed
I'll-
since long.
I'll just read on the order dated 3/2/2025 has not been complied, and it comes for the state a week's time to comply the order dated 3/2/2025. Lease the matter after 2 weeks ago. Interim order passed earlier shall continue till further orders complete.
Till further. My lord, there is a submission not related to this. My lord, certain matters your lordship had fixed to some days. Prior to your lordship was on leave for some time. So say 28th, 25th.
I'm adjusting those in the coming week. Don't worry. Don't worry. Yes.
Section 80.
May I please, Your Lordship?
Yes.
On behalf of Advocate Prashant Kumar Sahu, I pray for adjournment for 4 weeks.
Adjournment on the request. Yes.
God bless you.
81.
Last occasion, Your Lordship directed to issue notice to the OP number 2 with the wife and the informant in this case.
In this case, I am appearing for the informant and the
Yes.
victim as well.
Are you opposing or what?
Yes, my lord, I am opposing. Let them, let's file. He is seeking quashing of cognizance here in this case.
Okay.
The case under section 498 and the other salary.
498 and all.
498.
Why don't you settle? The idea is
Section 9 petition is also pending in the family court, Jaipur.
shall I send it to mediation try?
Mediation.
I'll just send it to mediation.
Mediation.
Mediation court, yeah? High court mediation.
Obliged.
Because the dispute is arising out of a matrimonial court. Notice was issued to the opposite party while order dated 22/11/2024. So entered appearance for opposite party. The legal counsel for the petitioner submits that the scope of settlement in this matter. The counsel for the opposite party also is of this similar view, hence relevant to the matter and awaiting mediation report. Please the matter. Yes, sir.
82.
That a date will be fixed because mediation date fixed.
They will fix the date and tell you. Yes.
82.
It's a quashing of affair offenses under section 354, 354A. Allegation is a petitioner wrongfully restrained after his modesty. In the meantime, my lord, the matter has been settled between the parties. Now he is appearing on behalf of the opinion to and filed affidavit.
Where the parties are there?
Parties, another date may fix so that I will call.
So entered
Some
appearance
date
on
may
behalf
fix.
of the opposite party and seeks an adjournment. Lease the matter both the parties, both the counsel for the party conjointly submit that the matter has already been settled between the parties. When do you want? 7th?
In next is
7th or 10th?
7th.
7th. Okay.
7th, 10th, 10th.
Say 10th, keep it on 10th. 10th. Monday. Okay. Bring them. Bring them. Yes.
83.
Yes.
May I please? This case, my lord, the petitioner 1, the husband, petition 2, the father-in-law, petition 3, the mother-in-law, my lord, or the opposite party note 2.
Yes.
Here, my notice issued. The cognizance taken under section, my lord.
Service is
subset, my lord, my friend appearing for the wife.
But here it will 50-year case. How they are suppressing as a spoil the life of a girl. Lordship can go through the affair. And now they are challenging the order of cognizance.
This is 498A.
498 Lordship.
No. Why don't you try and settle it up?
No, but on the
I'll send it to mediation.
No, my lord, what happened?
All right.
Try once. If it doesn't happen, then we'll go into
Yes, my
marriage.
What happened in this case, my lord? Actually, marriage has been dissolved, my lord. Wife,
whatever.
Yes, my
You
lord.
try once.
That
The matrimonial dispute don't bring technical. If it is settled, nothing like that. If it is not, then we'll see.
Right, my lord. Send it, my lord.
Same order for you. Same order for you.
Lord, fix a date.
I'll wait for mediation report. Thereafter, I'll decide. Yes.
Okay.
84.
Yes.
This was issued.
Notice. Dekho.
Already issued. And it was solved that a opposite party has already appeared. But 2 occasions was absent. It is not appearing. You also may kindly see the cost criteria.
Pramod Kumar Lenka.
Pramod Kumar Lenka is appearing, but is absent.
Very
Twice he is absent. So we say the petitioner is a inspector in charge of Jagatsinghpur police station. If protest person has been filed.
no, twice. The matter was only listed once. 7/12/2024, the notice was issued.
Then 6/2.
Thereafter, the matter never issued.
6/2. 6th February. 6th February hitla reach karna.
Ah,
The last person.
service IIC throughout the service group. IIC, this is complaint case, huh?
Yes, sir.
The none appears for the opposite party number 2, despite service. In the interest of justice, one more opportunity is granted to the opposite party. Leads the matter on settings like the entry order pass. Entry order pass on 7/12/2024 shall continue till further orders. Leads the matter good week for you. Good week for you. There 30. Yes.
Please, Your Lordship. So on the last occasion, Your Lordship was directed to file confiscation sheet.
Yes. Yes.
Yes. In that, my lords, that's 5,58,500. My lords, the asset of a stranger, my lords. My lords, I have annexed that document of the DSR, my lords, which is in the name of one Soilendra Pradhan, my lordship. Stranger, my lords.
Stranger to you or stranger to the prosecution?
Prosecution.
Stranger to the prosecution.
My lords.
Yes.
And my lords.
Yes.
And one loan amount is, my lords, 8 lakhs, my lords. That is also mentioned in the.
Where is that 8 lakhs? It's not there.
That is in the Roman 3, my lords.
Yes. Loan is 8 lakhs. Yes.
Loan 8 lakhs, your lordship. And
what
what
exactly you want to emphasize? You tell me.
Once they file counter, my lords. And there is also a delay of, my lords, 21 years, my lords, more than 2 decades, your lordship. No charge has been framed, my lords.
The FIR was registered,
my lords,
on 23/6/2004.
2004.
Charge sheet was filed.
My lord, charge sheet was 29/9/2007. My lord.
And what is the stage now?
My lords.
What is the stage, Mr.?
Charge was not in.
Why? Who is responsible? Is it attributable to the petitioners or what?
Another is responsible. Actually, nahi. Thing is that another aspect. Admittedly, comparative statement will not.
Huh?
Comparative statement will not.
Yes, show me.
Yes,
This one. Yes.
okay.
What exactly you want to say? Let me understand that. Total DA charge is 29,65,272 rupees. Wow, what do you mean by stranger?
He's saying that.
What is the stranger? What do you mean by stranger? How his money has been taken into account?
Asset stands in the name of that person has been included. He's saying that it should be deducted.
That may be, but
And it is based on documentary evidence. That is they are, so far as I understood, they are claiming it is based on purely on public document and documentary evidence, which is part of the prosecution record. It should be taken.
How many accused are there here?
Here, husband and wife. Petitioner is the husband.
Yes, let me see the first.
Fourth lordship can be of my counter. That is the contention of the petition. The Lordship got it?
1 minute, let me see that. What happened to the wife's petition?
Why that dishonorable court, coordinate bench of another bench, judgment has been discharged.
Then we have to await the judgment of await the judgment. And first of all, you are not, none of you are able to tell me what is the stage of the trial.
Several times charge has not been.
What is the reason? You must know.
In
See,
that-
2004
Honorable Court has passed an interim order to that extent, not to proceed in the trial.
which court? That court. Who are the other petitioner?
He has the court, she is the court.
Who are that? But what happened to this principal accused?
The proceeding,
Where is that order? Do you have that?
As if I was conducting that case, I called it a pronouncement of judgment, it will not be proceeded. So,
Then that's the problem. That's the problem. Right.
and here is the case, they are saying that it's less than 10%, 3%.
Less than
3%.
if that 5 lakhs is taken out.
If the incomes, the was done properly document, which are part of the proceeding is completed, and then it will be less than 3%.
If the 5 lakhs is taken out, then it will be 24 lakhs.
24 lakh, then the legitimate income, which are not being considered.
Public documents and part of prosecution. IT return 12 lakhs.
12 lakhs.
Sale consideration of immovable property.
2 lakhs.
What immovable property? Which immovable property you are talking about?
Do the item serial number 1 so that this for that.
No, this is.
We are not disputing. Thing is that another what we are disputing is that is he has not taken para 5 for your lordship, para 5 to my counter your lordship.
What I'll do is I'll await the outcome of this and ask for the report from the trial court. List it on. You tell me you put the proceeding of that court.
May I suggest one thing? Well?
Yeah.
Let that order comes, judgment comes in respect of court.
That's what I'm saying. Suppose if I exclude some part of the amount and that judgment is otherwise, what will happen? I don't know. This is very two different courts. The prime ground of the petitioner, apart from besides the merits of the case, is that the FIR was registered way back in 2004, whereas the charge sheet was filed. Although the charge sheet is filed on 2000 in the year 2007, the trial has not proceeded in inch as yet. The reasons for belated trial is not coming forth on the record. Therefore, a report, therefore, so is directed to place a report before this court regarding the stage of the trial. Mr. Maharana and counsel for the petitioner further submits that insofar as the co-accused is concerned, her petition seeking quashing being CRLMC number so has already been heard by the coordinate bench and judgment is reserved. Hence, he submits that ideally the matter may await the judgment of the judgment of the judgment of the coordinate bench. Lease the matter on 13th of this month. 17th of this. Okay, 17th. Yes. Partly heard the matter partly and then yes.
Then you change.
Yes.
Can be.
Entry model continue. Yes. Quickly here. Any short matters? Very short matter one can. Acha 104. Yeah, who is there for 104?
My lord, 194.
Madam, 94, that is a probate of the will. And actually the will has been found out after 7 years of the death of the evidence. So it has to be admitted and notice has to be issued. 94.
94.
And the police also has given a report that it is a forgery document. And learned court below has not.
94 notice कर दिया. Notice.
We are obliged much.
92 be disposed of.
We dismiss.
Can be disposed of.
Dispose of. 92. Yes. 1 minute. 92. One after another. 92. What happened?
Yes,
92. Settle. Dispute settle.
Discussed our amount is 21,43,280.
Dispute is settled or not?
Yes.
Yes. Give me.
18,75,000.
You are appearing for.
I am for
the employer. He is for the petition.
Complainant and is the insurance.
Have you got anything in writing?
No, we have not prepared. We have discussed and finally, my lord.
And file a composite petition tomorrow.
Yes.
Composite this thing. I'll take it on record and then.
Yes.
On the oral statement, I can't do it. Kali pe rakh do it. We will tomorrow. You come with the composite this thing. I'll dispose.
Yes.
Okay.
Item 90.
90.
Yes,
May I make a
1 minute. 91. Let us see 91. Yes. Who is appearing for respondent?
I'm for the appellant. Totally amount already deposited.
Already deposited.
My lord.
What is the amount, madam? Agreed amount?
Agreed amount 8,25,000.
Let him say that.
My lord.
Yes.
8,25,000.
25.
My lord.
Agreeable to that.
My lord.
Okay. Presence with you. Wakalatnama is there?
Yes, madam.
Yes, ma'am.
Your Wakalatnama is there?
Yes.
Yes.
My lord. Ground number C, their ground may kindly be reflected in ground number C.
C.
Ground number?
C, my lord. I have star marks dates in the collector code.
Yes. There is no ground.
Page 6, running page 6, man. Ground number 6. In the appeal memo.
6. Para 6.
Yes, sir.
Oh, there is not ground. These are only
Page number 6. Page number 6, man.
Page number 6.
6.
Ground number?
C, man.
There is no C, nothing. Which matter? 91.
90, my lord. 90.
Oh, 90. Okay.
Yes.
90. Okay. C, yeah? Yes. C. What do you want to say?
Then, no, they want to add that ground that during course of his treatment he has expired because of the accidental injuries. That ground might be reflected in.
No, what is the use of it? You have settled it.
No. Yes, no, matter has been settled.
Then
I am submitting on his behalf. The senior is not here for that reason. I submit.
what is the purpose of writing the ground? If you have settled the dispute,
Yes,
settle the
yes.
dispute. Yes. 90, yeah. Nine zero, huh?
Yes, ma'am.
90. You are appearing for all the respondent, madam?
I'm for the insurance company.
There are 3 respondents.
Appellant.
2 and 2, 3. 1, 2, 3.
Respondent, madam. 1 to 2.
Huh?
I'm for the appellant.
Appellant.
My lord.
Who is you are for?
I am for the respondent.
All the 3. All the 3.
No, madam. I am for the respondent number 1 and 2.
1 and 2.
Yes, ma'am.
What about 3?
3 is the owner.
Owner.
Who is appearing?
Nobody is appearing, madam.
Tomorrow he will start doubting.
He has admitted in his written statement, madam, with regard to employment of the deceased, madam.
Service completed. Told for this very good. Non-APS for opposite party number 3. He said non-APS for opposite party number 3. He is the owner.
Owner of the
Owner of the
Owner come employer, my lord.
employer.
Employer. It's workman compensation, so he can employ.
Recovery rate is recovery.
No, in workman compensation, there is no recovery, man.
Then no problem. The petition number, opposite party number 3 is stated to be the owner of the factory, yeah, owner of the factory and the despite service, nobody had that. Separate account.
Item
93.
I have appeared for the claimant respondent, my lord. My name has not been in the cause list, my lord.
What's your name? 93.
I'm for that.
Respondent now reflection. Name of so and so reflecting. Yes. Yes.
Sorry.
My lord, in that appeal, my lord, item 93, my lord, we file an IFS stay, my lord. Stay may be granted, my lord.
Yeah, have you deposited?
Yes.
Where is that?
There is noting, my lord.
Where is deposit proof?
Receipt showing deposit of awarded amount receipt.
In view, receipt is there. In view of
Next week I can dispose of that.
next week I'll reach this.
Next week dispose of
Yes.
No, state of how
Next week.
89.
stay may be granted.
Next week. Next week come here, deposit of
89.
My lord, I am appearing on behalf of the respondent number 3 in this case.
89.
90.
Number. Yes.
I do 89. I'm for the applicant. My lord, it's in the
89.
89.
Ah.
I'm for the applicant.
I respond. The claimant respond number 1. And he wants the matter may be taken up on 17th. In the meantime, we will take instruction from the company.
Settlement. Okay, 17. 89, 17.
Entry order to be continued.
87 let's take it up
Next week look.
89. Entry order to be continued.
Entry mode. Okay, yes.
Then context.
Yes, anything? FAR?
Next
week 95. Yes. Entry mode to continue. Yes.
91. Item 91, which I have appealed for the claimants respondent 1 to 4.
My lord, here, my lord, we are filing the original.
For the appellant. Today they are depositing the amount.
Awarded amount. Original deposit receipt, my lord.
91.
Yes, 91 can dispose of, but the notice is
No.
required to send to the owner of the vehicle.
Owner of the vehicle.
Okay, notice to opposite party number?
Item number 91, my lord.
91. Opposite party number?
Opposite party number, my lord.
3, 4.
No, my lord. Opposite party number 5, my lord.
5. Opposite party number 5. Issue notice to opposite party number 5. The appellant has produced the receipt of a deposit. Receipt of deposit of the award amount before the commissioner, which is taken under court, which is please the matter. Would we
On that. Lordship will fix it.
next week?
Item 96, my lord.
Next week, my lord.
File the requisites.
My lord, file the no, on that time, my lord, not disburse the any amount to the claimant, my lord.
The amount deposited before the commission shall not be disbursed. Yes.
Item number 88, my lord. Lordship may take it off next week, my lord.
Yes, 88 next week. Yes. Are you settling?
Yes, ma'am.
Yes.
My lord, there is an interim order, my lord. That may be continued.
Entry order. Yes.
6. Vigilance supplement was 8 years. This matter was listed for several occasions. But I said
Copy state
State region तक दिया तो?
You get state the results of
copy
Let it be there, Murshi. Yes. Let it be there. It is there.
Another
104. Let us see. 104. What is it?
One more submission. Sorry, madam. Item 1 to mention as appeal the judgment is the first. If notes of submission kindly kindly take care of my last para of my submission. That is the submission.
I beg your pardon.
Formal.
I beg your pardon to make a mention, my lord.
Style agent. It was trap case. Your lordship, the observation is necessary on that.
Beg your pardon to make mention, my lord. In item number 93, my lord, lordship may order that not to disburse any amount, my lord. Lordship may, we are already deposit, my lord. Lordship may
Which
keep-
item you are talking about?
93.
93.
Disbursement of.
Not to disburse.
Oh, bless you.
104.
You settle with dispute, disburse or not, no disburse. In any case, you have to pay. Yes.
Then my lord 104.
104, yes.
I am
Who is appearing for the state, madam?
Yes, my lordship.
Yes.
I am custody my lord 21/9/2021.
21?
9/2021. On the
21.
acquisition of my lord carrying
9
of
2021.
21.
Yes.
On the acquisition of carrying of my lord contraband my lord 37 kg.
37 kg.
Kg.
Now, ganja.
Yes.
And my lord IA number 1227 of 2024 for bail my lord.
Yes, madam, what do you say?
My lordship, they have filed this appeal only on the ground that non-compliance of certain provision of the NDPS, my lordship. While dealing with this matter, my lordship, the judgment passed by the lower court, my lordship, has covered all the everything, my lordship, along with the judgment. So, my lordship.
Data hearing.
On merit, do you have any case?
Yes,
I'll
Lord,
dispose of the
definitely.
appeal.
No, my
Yes.
Dispose of the appeal itself.
Yes, ma'am. No problem.
Okay.
If my lord may speak tomorrow, day after tomorrow.
I will file along with all the written notes of submission, my lordship. They, in the written notes of submission, they have filed. They are saying on the ground non-compliance of section 42 and section 50 and section
52A.
52.
Representative
Like this,
Miller.
my lordship. All has been dealt by the lower court while passing the judgment.
Get ready. I'll
Yes,
hear
ma'am.
the appeal. Yes.
So tomorrow.
It is there. I will not touch it. It is in the weekly list.
Yes,
every day.
Lord, I already filed the Miller written note of submission.
You get
If-
ready.
I am
Get
ready.
so that I can.
RTBL of the
Yes, my lordship.